So I request participant number 101, 102, 103, 104, and 105. Oh, are they present here? Kindly raise your hands. For presentation number 1, 2, 3, 4, 5. I request every participant to make sure that your mic is off during the presentation of other participant. Whenever it is required that you have to say something, we will call you, then only you will switch on your mics. Unnecessary disturbance will not be allowed. So for presentation number 1, 2, 3, 4, 5, we have Dr. Karunesh Shukla sir to judge and our team member, one of our team member from Into Legal World, Ms. Shweta. Dr. Karunesh Shukla sir is currently serving as assistant professor at Amity University, Patna. He has qualified his BA from Allahabad University, LLB from Banaras Hindu University in 2012, and his LLM from Indian Law Institute from Delhi, and he has completed his PhD from Banaras University uh, in 2024. So we welcome you, sir, on behalf of TS Mishra University and Into Legal World. Thank you for giving your time in our seminar, and thank you for your contribution as a judge. So now I would like to request our presentation number 1, participant code 101, to currently switch on their camera. Uh, Dr. Karnesh, sir, I would request you also to kindly switch on your camera. Thank you so much, sir. Thank you, Shweta. So, Vineet, you are required to share your screen. Kindly share your presentation with us.
Good afternoon to everyone. My participant code is 101, and I am presenting my views on the topic enhancing victim rights and support mechanism. Enhanced protection of victim rights and support mechanism is a crucial aspect of a just and equitable society. It ensures that individuals who have experienced crime or victimization receive the support and justice they deserve. Some key aspects of protection and support mechanism can be implemented: legal rights and protection, clear legislation, comprehensive laws that explicitly outline the rights of victims, including the rights to be informed, participate in legal proceedings, receive restitution, and access support services. Victim-centric justice system, a justice system that prioritizes the needs and well-being of victims, ensuring their voices are heard for and their rights are respected throughout the legal process. Protection orders, effective mechanisms for obtaining protection orders to prevent further victimization and ensures the safety of victims. Support services are also available in our constitution: 24 into 7 crisis hotlines, easily accessible hotlines staffed by trained professionals who can provide immediate support, information, and referrals to victim in crisis. Financial assistance programs that provide financial assistance to victims for medical expenses, lost wages, and other economical losses resulting from victimizations. Awareness and prevention, public education campaigns, and early intervention programs are also provided by our government and our law also. Raising awareness about victim rights and support services through public education campaigns and community outreach programs. Implementing programs that addressing the root cause of violence and victimization, such as bullying preventing programs and conflicting resolution initiatives. Specialized support for vulnerable populations, child and youth specialized programs and services that address the unique needs of child victims, including child-friendly spaces, trauma-informed care and support of their families, individuals with their disabilities, accessible and inclusive support services for victims with disabilities, ensuring their specific needs are met and their rights are protected. Old adults programs that address the specific vulnerabilities and needs of older victims, including elder abuse prevention and support services. Technologically based solutions also are provided. Online reporting platforms and some of mobile application you can say active alerts, citizen COP, Safe Night are also provided by our government. By implementing these measures, we can create a more justice and compassionate society where victims of crime and victimization receive the support, protection, and justice they deserve. Here is a case related to BNS, the Kedarnath Singh versus State of Bihar 1962. Supreme Court judgment is a leading case related to Bharati Nyaya Sanhita indirectly. This case dealt with constitutionally of the Indian Penal Code section law Section 124A related to BNS. While the BNS does not directly replicate Section 124A, it does addresses offences related to national integrity and security. The principles established in Kedarnath, such as the distinction between criticism of government policy and incitement to violence, remain relevant in interpreting and applying provisions within the BNS that deal with similar concerns. Thank you.
Thank you so much, Vineet, for presenting. Our next presentation, I would like to call participant code 102 with his presentation.
Hello, am I audible?
Yes, ma'am, you're audible.
Okay. Am I allowed to share my screen?
Yes, you can.
Okay. Give me a second. I'm sharing my screen.
Sure, ma'am.
Okay. Um, I'm sharing the screen then.
Sir, is this screen is visible to you? Both the judges?
Yes, it's visible.
Okay, I'm starting then. My topic is evidentiary challenges in cyber fraud. Firstly, a very good afternoon, everyone. My name is Shreya Chakraborty. I'm a PhD research scholar at University of Calcutta. Today, I'll be presenting on the aforementioned topic. With the rapid increase in cybercrime, particularly financial fraud, this topic has gained critical importance for both legal systems and digital forensics. The increasing prevalence of cyber fraud highlights the significance of highlights thus significant gaps in traditional legal system, especially in handling digital evidence. My study focuses on the Bharatiya Saksha Adhinayam, or the Indian Evidence Act, which was recently amended in 2023 to address these challenges. Despite these updates, complexities remain in the authentication, preservation, and admissibility of digital evidence. Cybercrime in India has risen by 15% in recent years, underscoring the urgency to breach the gaps between forensic methodologies and legal standards. Evolution of the Indian Evidence Act. The Indian Evidence Act 1872 was originally designed for physical and documentary evidence. Over time, the Information Technology Act of 2000 introduced Sections 65A and 65B to cover electronic records, but these provisions faced criticism for being vague. The 2023 amendments marked a pivotal shift, expanding the definition of evidence to include metadata, blockchain records, and cloud data. Key changes include mandatory chains of custody documentation, dual authentication for admissibility, and empowering forensic experts in court proceedings. Digital forensics plays a central role in cyber fraud investigations. Techniques such as hashtag and metadata analysis ensure the integrity of electronic records. Preservation involves tamper-proof copies, creating a via disk imaging, while network logs and AI-driven tools help reconstruct fraudulent activities. Despite these advancements, challenges persist due to inadequate infrastructure and shortage of certified forensic professionals. The amendments address these issues by emphasizing expert testimonies and advanced methodologies. Judicial perspectives and case studies. The judiciary has been instrumental in interpreting the admissibility of digital evidence. Landmark cases like Arjun Pandit Rao Kotkar versus Kailash Kushan Rao Gorantial emphasized Section 65B certificates for electronic records. Other cases, such as State of Tamil Nadu versus Subhash Katti, highlight the critical role of timely evidence handling. However, ambiguities persist, as seen in Shafi Mohammed versus State of Himachal Pradesh, where alternative methods for verification were debated. The 2023 amendments seek to resolve these issues through clear guidelines. Recommendations. To strengthen the evidentiary framework, I propose the following: legislative refinements to address jurisdictional challenges and include AI and information technology provisions, capacity building through accredited forensic labs and training programs for legal professionals, technological integration such as blockchain for chain of custody and AI tools for data analysis, global collaboration to align Indian laws with international best practices. In conclusion, the 2023 amendments to the Bharatiya Saksha Adhinayam are a step forward in tackling cyber fraud. However, effective implementation, international cooperation, and skill enhancement remain critical. By bridging the gap between technology and law, India can ensure justice in the digital age. Thank you.
Thank you, Ms. Shreya. So before proceeding, I would like to brief the presentation instructions again, that you are not allowed to take your university or college name or at the designation which you are on. And also, you will only be having 7 minutes to conclude your presentation.
Okay.
So for the next presentation, I would like to call presentation number 3. Kindly present your paper.
Yes. Yes, a very good afternoon to everybody here. I am the presenter number 103, and my topic is with regard to the the framework for admitting electronic evidence under our BSA. See, the move from the Indian Evidence Act 1872 to Bharatiya Sakshya Niyam and Bharatiya Sakshya Samhita in 2023. These things, mark a very momentous change in our Indians' legal landscape, replicating the need for transformation and acclimatizing to the changes in the society, governance, and technology. And this journey lends over a century and has perceived the evolution of legal norms surrounding evidence were swayed by factors such as colonialism, judicial reforms, and digitalization. And with the advent of the digital technology, which has revolutionized the way the information is generated, stored, transmitted, And all this, as a result, electronic evidence has become very increasingly important aspect of the legal proceedings worldwide, not only in India. But in India, the Bharatiya Sakshya Adhiniyam that has been, enacted to provide a framework for admitting electronic evidence in Indian courts. And currently, the digital evidence has urbanized and emerged as a foundation stone in the modern legal framework, which is considerably modifying the process of litigation. It is also modifying the investigation, and the judicial proceedings are all, piloted. And now let us just see what is that the electronic evidences includes. They include, the social media interactions, photos, emails, which are shared electronically, files, or even the metadata too. And all of these, play a very vital role in either proving or disproving a case. And furthermore, we find that digital evidence can be temporary, capable of being deleted or even changed with ease. And however, even when deleted, it hints that the digital evidence often remains on devices. It doesn't go anywhere, and which can be accessible through advanced forensic tools. Say, for example, the metadata, which can provide information about the creation, transmission of digital files, and modification, can reveal, very, very crucial details. Now, let's just look into the electronic and the digital evidence under the Indian Evidence Act. See, the courts constantly requires the evidence to rely on the facts and issue which are cited before it, and concurrently, the courts also acquire a definite rules to be placed as evidence before it. And according to Section 65, see, all here, we are more concerned with the Section 65A and 65B of Indian Evidence Act. And 65A of Indian Evidence Act, it says that the electronic records have to be proved in accordance with Section 65B. And which states that the admissibility of electronic evidence, the Supreme Court stated in a judgment, there's a requirement of a certificate in accordance with the Section 65B of the Indian Evidence Act, 1872. This is actually a condition precedent to the admissibility of the evidence of the electronic records. And Section 65A and 65B were inserted into the Evidence Act through the Indian Evidence Act Amendment Act of 2000, and which became a part of Chapter 5 of the Act, which deals with the documentary evidence. And Indian Evidence, this Amendment Act introduced certain changes, such as, it had to expand the definition of documentary evidence to include this electronic records. And the definition of electronic records is again given under Information Technology Act of 2000. And this electronic record, which means, like data, record, or data generated, image, it could be image or sound stored, received or sent in an electronic form, or microfilm, or computer generated, micro fish. It makes it very clear, that there are two special and separate provisions, which deals with electronic evidence. Say, Section 59 of Indian Evidence Act states that all the facts except the insides of the electronic records or documents could be proved by oral evidence, as it is based on the fundamental principle of the best evidence rule. And Section 65A again affords that the contents of the electronic record may be proved in accordance with the provisions of the Section 65B. And 65A provides for a special procedure for proving the contents of the electronic record. In furtherance thereof, Section 65B provides for the procedure. And we have seen that the Honorable Supreme Court has emphasized on the distinction between the primary and the secondary evidence, which is certainly applicable to the electronic records as well. And information contained in the computer is considered as primary evidence, and the output, generated from the computer, which contains such information, is treated as a secondary evidence. So, supposing in a situation where, which is contingent to the original electronic record to be produced in the court, then the owner of the device may have to testify and prove that the device in question on which the original information is stored, which is, first is either owned or operated by him. In the event of electronic record is a part of the computer network, or say the computer system, and where it is not possible to physically bring the system to the court, the only way to prove the information contained in such an electronic record is only through 65 A and B of the Indian Evidence Act. And this criterion is also mandatory to provide, info to the investigating agency, which is very, very crucial. now we'll just look into the changes introduced under the Bharatiya Sakshya Adhiniyam, that is electronic evidence, which is treated to be as a primary evidence.
Have only 1 minute more to conclude.
Okay, so I will just quickly go through the other key changes. Instead of going into details, I'll just say the welcoming change which was introduced by the BSA is the oral evidence, which now includes any of these statements given either electronically by by the witnesses as well. And this will facilitate witnesses, including the experts, to record the statements and to be cross-examined. All these things can be done through audio and video, thereby allowing more conveniences and flexibility to expedite the trials in India. And to conclude, I would say this change which is brought in by the BSA is a great appreciation of the ever increasing importance of the digital evidence in India. But however, in practice, they could create more difficulties than they seek to address, because there is an imminent need for precision on what the electronic evidence would constitute, like say the primary versus the secondary evidence, as the latter is subject to the requirement of producing an authenticating certificate under Section 63 of BSA. And the BSA is overlooked opportunity as it fails to address several other areas relevant to the electronic evidence, such as expounding of proper chain of custody for electronic evidence, providing assistance in relation to the safe storage and disposal of the electronic evidence, setting apart the privileged and the confidential information. They're addressing questions in relation to the probability of self-incrimination, which is inherently linked to the seizure of electronic data from a person. So this BSA is a step forward towards launching a framework for electronic evidence, and it is a very, very precarious step and would benefit from the judicial or say the legislative intervention in order to provide some much needed certainty into it. So with this, I conclude, and thanking the organizers for giving me this precious time to present my paper. Thanking one and all. Thank you.
Thank you so much, ma'am.
Thank you.
So for the next presentation, I would like to call presentation number 4 of participant code 104. Kindly be present with your paper. Presentation number 4, participant code 104. I would like to inform judges that sir and ma'am, if you are having any kind of question related to the paper, you may ask to the participant. So for this presentation, do you have any question to ask?
I would like to. Yes, please, Tanu.
Yes, ma'am.
Yes.
Please, go ahead.
I would like to ask, what are the points or what are the points which you, from your side, that you would take into consideration in regards to the electronic evidence, like any innovation from your side, or it's just a literature review from your side?
Presentation number, this question is for presentation number 3.
Yes.
So I would request that participant to kindly answer.
Yes, ma'am, I'm here. Could you just again, repeat the question, ma'am? Sorry about it.
Yes, I would say that is this a literature review from your side, or is there any other points that you want to add in regards to electronic evidence? And do you think that the current legislations for electronic evidence is actually working, or is there any flaws regarding that?
Yes, ma'am. See, this is again the confusion which is still revolving around the primary evidence and the secondary evidence. Because we need more precision in this matter, because they are all asking for an authenticating certificate. which was also there in the Indian Evidence Act, but that was, treated differently. And the Section 3 of BSA is again, treated differently. And somewhere we find, there was one judgment also, which was given where the where it was involving more of a data integrity, because the party tendering the certificate of electronic evidence along with an expert now obligates recording of a hash value of the electronic evidence during times of submission of the certificate, because the gap over here under BSA is that it misses the mark to provide a suitable safeguards, while storing, say, for collection and disposing of digital and electronic evidence during the investigation processes. So therefore, what happens here is, even while dealing with the confidential and the privileged information that may be collected during the investigation processes, because there are no safeguards which has been, clearly stated in the Act.
All right, sounds good. Sir, you may please.
Okay. Hello, presenter number three,
Yes,
right?
sir.
Uh, in Indian Evidence Act, we had a provisions for electronic evidence for 5 years time limit, right?
Yes, sir. Yes, sir.
And Bharatiya Sakshya Adhiniyam also comes under the same line, 5 years.
Yes, sir.
Do you think we could have changed this time limit, like 20 years or 30 years, like the normal evidences, normal documents? Did you
Yes,
work
sir.
on
Somewhere
this
I feel
point?
this. Yes, sir.
Did you work on this point?
Yes, sir. Yes, sir. I also feel that it should not be limited to 5 years. Because sometimes there are many instances where, the crimes could be dug beyond. And then if you will limit it to 5 years, then, after the 5 years, even though the evidences in this electronic form are there, it will become inadmissible. So that should not be the case. I mean, I feel that a time limit of 5 years should be removed
Oh,
and could have remained silent with regard to the period.
okay. Thank you.
Sorry. Okay, thank you, sir. Thank you.
Thank you so much, everyone. So for the next presentation, I would like to call again presentation number 4. I think due to some reasons, the participant number code 104 with presentation number 4 is not present here. So I would like to call presentation number 5, participant code 1.
Yes, go ahead.
Hello.
Presentation number 5.
Yes, hello. Isn't it?
Yes, yes.
Okay. I'm audible?
Yes, you're on.
I'm Let me share my screen. Mhm. Is it visible?
Yes. Judges, is it visible to you?
Yes, it's visible.
Okay.
Okay. Good morning, everyone. My presentation number is 105, and the topic is marriage related offenses and legal reforms, analyzing the evolution of justice in marital relations. So, marriage-related offenses uh, encompass a wide range of crimes tied to marital relations, such as domestic violence, dowry harassment, marital rape, which remain a very critical area where there is a need for legal reform in many societies. The paper examines how the recent legal reforms are reshaping and understanding the definition of these offenses, challenging the traditional norms and offering new framework for justice. Furthermore, the paper explores the intersection of cultural, social, and legal factors in these societies and enforcement of these reforms, while at the same time noting the discrepancies and the implementation across the regions. Now, uh, The now I would like to start with the introduction. Though the marriage-related offences include include domestic violence, adultery, harassment, marital rape, etc. In the past, traditional norms and cultural perceptions frequently protected perpetrators, framing these crimes as private matter rather than violation of human and violations of law and human rights. However, in recent years, there have been significant shift in the legal discourse regarding marriage-related offences. The evolving legal landscape now increasing emphasis on gender equality, human rights, and power dynamics within the marital relationship. Historically, many societies have condoned and overlooked the marriage-related offences. Domestic violence, for instance, was often seen as a private issue, why little recourse for the victim. Marital rape was not universally recognized as a criminal act, with many legal systems offering men impunity from the assumption of marital consent. In the last few decades, legal system across the world have started to recognize the importance of protecting the individuals within marriages, regardless of gender. This shift has been driven by many international human rights movements and domestic advocacy efforts, which were done all over the world. Now, one of the significant reforms have been in the criminalization of marital rape, which was once legal in many countries. With how historically marital rape was considered impossible under the assumption that marriage automatically implied consent of sexual activity. Legal frameworks often exempted husbands from prosecution of rape within marriage, considering the sexual act as a marital duty rather than a crime. However, the view has been completely contested, particularly in the late 20th century and early 21st century. Indian international human rights organization as well as feminist movement have played a pivotal role in the challenging of the legal foundations of the marital rape exemptions. However, the criminalization of marital rape has not been without controversy. In some regions, resistance remains strong, often rooted in cultural and religious belief that prioritize the sanctity of the marriage and the concept of marital duty. Alongside the criminalization of marital rape, significant strides have been made in strengthening laws against domestic violence. The legal reforms in this area have moved from mere recognition of abuse to more proactive measures aimed to preventing and punishing the domestic violence. Many countries have adopted a comprehensive domestic violence laws that provide victims with a wide range of legal protection, including restraining orders, access to shelters, and criminal penalties for abusers. In some cases, these laws have shifted the burden of proof and making it easier for the victim to seek legal remedies. In US, for example, Violence Against Women Act, that is VAWA, passed in 1994, provides federal funding for the investigation and prosecution of violent crimes against women, including domestic violence. In India, Domestic Violence Act in 2005 provides a legal recourse provides a legal recourse for the women who are victims of domestic violence, offering protection orders, restraining orders, and residence orders, etc. At the heart of these legal reforms is the promotion of gender equality. For decades, marriage-related offenses were often dismissed or justified on the grounds of a gendered role assigned to spouses. Furthermore, the gender equality laws are
Participant,
crucial
you
to
have 2 more minutes to present.
okay, okay. Gender equality laws critical for addressing the broader systematic issues that contribute marriage-related offenses. Now, I would like to say that cultural attitudes can also influence how the laws are perceived and applied. For instance, in some communities, marital rape may still be viewed as a private matter between spouse, not as a criminal act. Now, I would like to conclude that the ongoing legal reforms surrounding marital related issues including the criminalization of marital rape and strengthening of domestic violence laws, represent an important step towards achieving the justice and equality within marital relations. Ultimately, the legal strategies must be continually adapted to respond to evolving understanding of crime, justice within marriage. As societies change, so must their legal systems. Thank you.
Any question, judges?
Nothing from my side. Is there anything, sir, from your side?
No question.
Thank you.
Thank you.
Thank you so much, participant code 105. So here, I would like to extend my sincere thanks to Dr. Karunesh Sukla sir for being present here and for giving his precious time to us. Thank you so much, sir. And for presentation number 4, I will be sharing the paper with you. So if the participant is not present here, so we will be judging on the basis of the paper. So, sir, I will be sending you the paper for for participant code 104. Thank you so much, sir, for being present
So,
here once.
I have one question regarding that.
Yes,
Uh,
sir.
if he's not presenting his paper, then will it give him marks or her in the area of presentation?
No, sir. In the area of presentation, there will be no marking.
Only content, grammar, and originality will be
Yes,
looked at.
sir.
Okay. Thank
Thank you
you.
so much, sir.
Welcome.
So for next presentations, I would like to call Mr. Manvendra, sir. Sir, kindly switch on your camera. Mr. Manvendra Kumar Tripathi is an assistant professor at Nehru Gram Bharatiya Deemed University, Prayagraj, and he is currently pursuing research at the Department of Law and Governance, Central University of South Bihar. He holds a BA and LLB from DDU Gorakhpur University and LLM from the University of Allahabad. Mr. Tripathi has also qualified for the UGC NET in law. With a strong academic background, Mr. Tripathi has established himself as a prolific researcher and author. He has numerous publications and research papers, articles, and book chapters to his credit, and has presented his research at various national and international conferences. His areas of expertise include criminal law, women's law, commercial law, property law, and human rights. So, Mr. Tripathi, I would like to extend my sincere thanks to you for being present here and for giving us your precious time. So, with this, I would like to invite presentation number 6, participant code 106, to present his paper, to present their paper. Presentation number 6. I will request
Hello.
participants to kindly
Yes,
go
yes, yes, ma'am.
through the schedule which has been shared with you all.
1 second, ma'am. Good afternoon, all of you. My name. Hello. Am I audible?
Yes, you are
Yes,
audible.
Okay. Give me 1 second. I will share my screen. Sorry for the technical issue. Can I start with my, I have
Yes, you
technical
can
issue.
start.
Good afternoon, all of you, respected panel members. My presentation code is 106. Here I am presenting my views on marital rape and our judicial system. First of all, we should know that marriage is subject to a personal law, which is directly or indirectly connected with the society or influenced by the society. We are living in the society in which the consent of woman is not necessary, and the woman is treated like a property of a man and treated secondary. So first, we should know the what is the difference between will and the consent, because Section 375 of Indian Penal Codes uh, give both the will and the consent. But when it comes to the marital rape, the court change its with consent. So will can be dominant by other, but consent is not. So marital rape refers to a sexual intercourse without the consent of spouse. If it if the spouse age is under 18, it is criminalized. But if it is above 18, it is not criminalized. It is a form of a domestic violation of individual autonomy and dignity. In Indian Penal Code, it is defined in Section 375 and exclude forced sexual act by husband if she is above 18 years. In Bharatiya Nyaya Sanhita, which replaced IPC, continues exclude marital rape. But when it is the amendment of IPC and a British law, it should be amended. But it is not. Why? Because I think the government is not come to the conclusion that it should be criminalized. But it is a criminal offense if it is against the consent of a woman. It is important to note that while rape is not criminalized, women can seek relief under the Protection of Women from Domestic Violation Act 2005, which address sexual abuse within the marriage. However, this act only provides civil remedies, not criminal. Argument supporting in criminalization marriage does not mean that it is a permanent consent of a woman. It is a violation of individual human right and dignity. Victim suffers physical, emotional, as well as mental harm. What we can do for it? First of all, awareness. We have to educate society on gender equality and the consent and the importance of the consent. Remove the marital rape exception. Third, encourage dialogue to challenge outdated belief about marriage and consent. And fourth is open talk about this taboo topic, because generally we don't talk about it, and hardly four or five, very less case are registered for this also. So criminalizing it will empower women and ensure equality and dignity in marriage. My presentation is over. If you have any question, you can ask from me. Thank you.
Liz, do you have any questions?
I have one question.
Yes.
So we know there is one international convention, right? That is the Convention on Elimination of All Forms of Discrimination Against Women, that is
CEDAW.
CEDAW.
Yeah.
Yeah, so how do the Indian courts reconcile the marital rape exception with this international treaty and convention, that is CEDAW?
So the Supreme Court also held so many cases, and I don't like in their guideline also they criminalize it, but the law does not criminalize it. So we have the principle, we have the guidelines, but we don't have law for it. So there should be a proper law for criminalizing it. Yes.
Right, thank you.
Thank you.
These events,
Ji, yes.
there is a relation between marital rape and domestic violence.
Yeah.
What?
Okay. So domestic violence include any type of violence which is mentally, physically, sexually, and economically. So whatever comes to the woman after the marriage, in a form of violence with the husband and with their relatives too. It is a it is called domestic violence. But women are not aware of it that it is also subject to a domestic violence. They only know that if your man is beating and relatives are beating her, it is also sorry. This only a marital sorry domestic violence, but it is not like that. If a woman suffers from emotionally, economically, mentally, physically in any form, and after the marriage, it is a domestic violence. Am
Okay,
I?
I have one question.
Yes.
What are the challenges in prosecuting marital rape case in India?
What is the challenges? First is the awareness. Second, it is a societal pressure. Third, that the lengthy process of judicial system that like it took 5 or 7 years to get justice. So, and also it is a taboo topic. Like nobody wants to talk on it because if we are talking about this, we society being judgmental to her and harsh to her. So I think it is that all are the challenges.
Thank you.
Thank you so much.
Thank you so much, participant. Thank you so much, judges. So, for the next presentation, I would like to call presentation number 7, participant code 107.
Yes, ma'am. I'm visible or not audible?
Yes, you are visible and you are audible too.
Okay, let me share my screen.
Before starting, I would like to inform something to judges. The presentation number 9, participant code 109, has now been shifted to the last presentation due to some unavoidable circumstances. We are considering it. So, the judges will be judging presentation number presentation number 11 also. Participant code 111. Is it okay, sir? Is it okay, ma'am? Okay. So kindly add this to your score sheet, sir and ma'am.
Is visible? Hello.
Yes, it's visible.
It's visible now. Okay, myself, contestant participant number 107. Good afternoon to all of you. I'm going to present a paper on bigamy issue in India. So it will be a two-way presentation. First on bigamy on Bharatiya Nyaya Sanhita, and second will be the famous Satla Mudgal case. I will discuss both of them in these slides, as I have submitted the article as well. So the relevance of bigamy under Bharatiya Nyaya Sanhita. This presentation will explore the relevance of bigamy under Bharatiya Nyaya Sanhita, or previously as it was called as Indian Penal Code. We will delve into the historical context, key provisions, exceptions, penalties, evidentiary requirements, legal remedies, and social implications of the issue. The historical context of bigamy in legal system, the ancient root. Bigamy, the practice of marrying multiple spouses while the previous marriage is still valid, has historical root in ancient Indian society. Historically, polygamy was practiced in certain communities while monogamy was prevalent in others. With the advent of British rule, a unified legal system emerged codifying bigamy as a criminal offense. It was just after the British rule that bigamy was treated as an offense. So the British influence is very much there. The Indian Penal Code of 1860, influenced by British legal principles, criminalized bigamy. It aimed to establish a uniform legal framework across India and uphold monogamy as the norm. However, the application and interpretation of this law have evolved over time, reflecting changing societal norms and cultural practices. The key provisions regarding bigamy in Bharatiya Nyaya Sanhita section 494, as it was previously 494 in BNS, it's 82 and subsection 1. An exception to this law. The law recognizes certain exceptions to bigamy, such as the cases where prior marriage was dissolved through divorce or annulment. These exceptions are crucial for ensuring fairness and preventive justice. Burden of proof. The prosecution bears the burden of proving that a person knowingly and willingly married another while being already married. This includes proving the existence of the first marriage and the knowledge of the accused. These are the exceptions to the Bharatiya Nyaya Sanhita under 494. As divorce, if a person has divorced his first wife, then he is allowed to marry second. An annulment which declares a marriage void from the beginning, ab initio, that is, due to legal impediment, also allows remarriage without violating the bigamy law. Death of the spouse. In case of death of the spouse, either husband or wife, the surviving spouse is free to remarry without facing bigamy charges. Cultural practices. Certain customary marriage or tribal practices may have their own regulations regarding polygamy. Penalties and punishments of the offences. Imprisonment. The Bharatiya Nyaya Sanhita prescribe a maximum punishment of 5 years imprisonment for the offences of bigamy. The actual sentence depends on the specific circumstances of the case. Whereas in Bharatiya Nyaya Sanhita, the new one, it is also 5 years for imprisonment as it was in IPC. Fine. Along with imprisonment, a fine may be imposed on the convicted person. The amount of fine is determined by the court based on the gravity of the offence. While the law aims to deter individuals from entering into bigamous marriage, ensure justice and for those harmed by the action, and uphold the sanctity of monogamy. Evolutionary requirement and burden of proof. Marriage certificate is required. Witnesses are required, as in Muslim there are regulations of at least 4 witnesses, 2 male and 2 female are there. Other evidences, additional evidences such as photograph, letters, and religious records may be used to corroborate the existence of the first marriage and the accused knowledge of it. Legal remedies available for the victim of bigamous marriage: declaration of nullity, maintenance, criminal prosecutions, and societal implication and ethical consideration. Gender imbalance, cultural sensitivity. It is crucial to consider cultural diversity and ensure that legal
Participant, you
interpretation.
have 2 more minutes.
Okay, ma'am. Protecting the right. Just 1 second, ma'am. This was the bigamy under the Penal Code, a case study of Sarla Mudgal case. Section 494 and 495 IPC. This section criminalizes bigamy, defining it as an act of knowingly marrying again while a previous marriage is still legally void. And 495 IPC, this section addresses the legal implication of marrying a person who is already married, specifically stating that such a marriage is void. It emphasizes that the first marriage remains valid. Key takeaways from Sarla Mudgal judgment: marriage validity. The Sarla Mudgal case firmly established that a second marriage during the subsistence of a valid first marriage is legally void, and protection of a spouse. The ruling provide crucial protection for the spouse who are unknowingly involved in bigamous relation. In enforcing bigamy law, the judgment highlighted the need for effective enforcement of bigamy laws, prevent exploitation, and ensure sanctity of marriage. The loopholes: despite the strong legal framework, there are loopholes that individuals may exploit to evade prosecution, making it challenging to fully enforce bigamy law. That's all. Thank you, ma'am.
Thank you, participant. So for the next presentation, I would like to call presentation number 8, participant code 10.
Yes, ma'am.
I request the presentation number 7 participant to kindly stop the sharing of his slide. Thank you. So do you have any questions from participant number 7? From presentation number 7, do the judges have any kind of question?
No, ma'am.
No.
Yes, presentation 8.
Yes, ma'am.
Kindly start your presentation.
Okay, ma'am. Ma'am, am I audible and is my paper visible?
You are audible, but your screen is visible, not your paper.
Okay.
You have to open the file where you have saved it.
Ma'am, is it now visible?
Yes.
Okay. Sorry, ma'am.
You can start with your presentation.
Okay, ma'am. Good afternoon, everyone. Um, my presentation number is 8, and the topic of my presentation is the concept of community service as punishment under Bharatiya Nyaya Sanhita 2023, a boon or a ban. So, as we all know, that punishment is not a new concept. It has been prevalent in India since ancient times. Earlier, we used to connect with the we used to connect the good or the bad activities with the doing of good or bad activities, like hell and heaven. But with the passage of time and with the reign of different rulers in our country, the concept eventually changed. Earlier, there was a king who used to who used to give punishment according to him, whoever does any bad activity in his kingdom. But with the passage of time, everything changed. When we were ruled by the Britishers, then there came the codified law in our country, which came to be known as the Indian Penal Code, which was then codified and provided the statutory offenses definition and statutory punishments for different offenses. But prior to that, there was no just codified law in our country, and the rulers used to give punishment or used to treat the people according to themselves. Like we in ancient and medieval period, we used to see punishments like hanging, whipping, branding, mutilation, flogging, and even starvation to death. It was just after the Britishers when came to India, and they provided a codified law in the form of the Indian Penal Code. Then we have some uh, better punishment, and there were different theories regarding punishment in India. And the codified law, which by which we were governed, relied on basically two theories of punishment, which was deterrent theory of punishment, and the another one was retributive theory of punishment. But there was no such concept of community service punishing. But there was no such concept of community service punishing in India since it came in Bharatiya Nyaya Sanhita in 2023. So my research paper objectives will be to learn about the scope and implementation of community service. Second, to look into the difficulties the court may have when it comes to community service punishment. To ascertain how the community service punishment affects both the society and the offenders. Last but not the least, to determine whether community service sentencing will be helping offenders to reintegrate into the society. The research questions of my paper will be: what is the nature and the ambit of community service sentencing in Indian penal system? Can community service sentencing result in declining rate of recidivism? What are the possible challenges which can occur in implementing community service sentencing? Does community service sentencing be able to bring positive changes in attitudes and behaviors of offenders? I would like also to tell you that my research, the research paper which I have presented before you is purely doctrinal in nature, because I have collected all the matter from different statutes, text, and literature available on the net. Now, I will be defining what is actually community sentencing. Community sentencing, also known as a non-custodial sentence or community service, is a legal framework that permits judges to punish offenders in ways other than the traditional incarceration. However, community service is not a new concept if we see at the global level, because it has been practiced since uh, long time in many countries. But in India, we can say that explicitly it has been It has come only after BNS 2023. However, there were judicial interpretations before BNS 2023 which indirectly provided community service punishment to many offenders. Like I would like to highlight the cases like State versus Sanjeev Nanda in 2012, in which the Ministry of Social Justice and Empowerment was ordered by the court to provide the offender the community service for 2 years, and upon his default, he will be punished for 2 years of simple jail. Next was the Parvez Jilani Sheikh versus State of Maharashtra, in which the court ordered the accused to render community service at BARC hospital. The most leading case was Sunita Gandhar versus State of Madhya Pradesh, in which the court ruled that in accordance with Section 437, Clause 3 of CRPC, the accused may be subject to any other conditions in the interest of justice through community service and other relevant reformatory measures. Manoj Kumar versus State of Delhi. For a month, the offender was ordered by the court to perform community service at Lok Nayak Jai Prakash Narayan Hospital on Saturdays and Sundays. I would also like to highlight that
Participant, you have 2 more minutes.
okay, ma'am, that earlier attempts were made by the legislature to adopt community service as punishment in our penal system, but they were all in vain. Through the Law Commission in its 156th report recommended for adding community service as a punishment, and also removal from office, injunction to pay reparation, and public censure. But the legislature did not permit and did not added this punishment in Indian Penal Code. I would also like to highlight that section number 4, chapter 2 of BNS 2023 provides the statutory punishments, which includes community service as one form of it. And some of its provisions which provides a community service as punishment include section 202, which says that public servant unlawfully engaging in trade. Section 209, which talks about non-appearance in response to a proclamation under section 84 of BNSS 2023, Section 226, attempt to commit suicide to compel or restrain exercise of lawful power. Section 303, Clause 2 proviso, that where the theft value of the stolen property is less than 5,000 rupees and a person is convicted for the first time and returns or restores the value of the property. Next provision which talks about community service as a punishment is Section 355, misconduct in public by a drunken person. Last but not the least, Section 356, Clause 2, which talks about defamation. I would also like to highlight that in United States of America, it is a form of punishment from the mid 20th century. And I would also like to show the data in 2022. A total of 1203 offenders were placed on community service, with the sentences boasting an impressive success rate of 80%. Likewise, in UK also, the Criminal Justice Act of 1972 of UK provides the community service punishment, which is known as the Community Payback Order, which is provided in section 15 to 19 of the Criminal Justice Act of 1872. In Australia also, we see the community service punishment as a very good form of punishment, which has been provided by the legislature there. And but in Australia, there is a provision that in different regions of the continent, there are different provisions. Like in New South Wales, it is different. In Victoria, it is different. In Queensland, it is very different. The Nordic countries also has been shown a very effective result of the community service as a punishment. The Nordic countries, which includes Finland, Norway, and Denmark. And I would also like to highlight that according to the survey which is done by the World Justice Report, the Norway the Denmark was at the top position in the community service punishment, which was ranked by the World Justice Report, and India was ranked at 79 out of the 142 countries, which was not a good record. So seeing these records, I suggest that the community service punishment should be implemented in India. And the problems which we face if we'll not provide the community service punishment in India, like there is overcrowding in our jails which are prevalent in our country, which has been the data which I have provided from the Prison Statistics India. It shows that there was increase into 131.4% in 2022. The number of prisoners in jails increased by 14% from 4.8 lakh in 2022 to 5.5 lakh as of December 31, 2021. Also, the average person overcrowding rate in the country rose from 119% in 2019 to 130% as a result. So we see problems if we can see the benefits if we'll provide the community service sentencing in India, because there is already a overcrowding in our jails, and this theory is purely rehabilitative and restorative in nature, and it will also provide a declining rate in recidivism rates in India, and also it will also decrease the incarceration rates. And in at the last, I would like to suggest that the term, according to the research which I have done, uh, that the community service sentencing must be given proper legal definition as to what constitutes it and its proper undergoing term and consequences of its non-performance. Secondly, the legislature must provide some strict supervision agencies for the supervising the activities of the offenders undergoing this community service sentencing, as a lack of proper supervision might release the offenders into criminal activities. Third, the campaigns must be raised to the public awareness regarding the advantages of the community service through case studies and success stories, as required to boost acceptance and trust in the practice. Last but not the least, the proper criteria should be clearly and concisely laid down for the determination of offenders suitable for community service sentencing. With this, I would like to conclude that the Gandhiji very much believed in the saying that hating the crime should be there and not the criminal. So this community service sentencing properly appropriates or properly appropriate fit this theory, and is in line with the restorative values as laid down by the Gandhiji. And to encourage the implementation of community service orders as an alternative to incarceration, the court, legislative branches, and civil society organizations must collaborate, as it will bring the rehabilitation in the offenders and will bring a positive result in the society.
Thank you so much. If the judges have any questions, they can ask. If not, then we must call the next participant.
Yes, I have a question.
Okay, please go ahead.
What problem does judiciary face in sentencing community services punishment?
Sir, first of all, the judiciary must, the legislature must clearly let down the criteria. Matlab, if the judges declare some to some offenders the community service punishment, then there must be some criteria let down by the legislature as to what age group should be given the community service punishment, what will be the nature and the ambit, matlab who will constitute. What offenses will constitute the community service punishment? If there is no proper definitions or proper criteria, then how will the judges impose such punishments? They can put the ad through the discretion, but not in every case they can use discretion all the time.
Can you give some examples of community services?
Community services like teaching in schools, providing technical knowledge which you have, which the offender have, training and helping in the NGOs, and cleaning the parks, matlab, which I have studied in foreign countries, like community services provided in these form of punishments, and graffiting and all these things are providing education to children who are not able to get the education.
Thank you.
Thank you, sir.
Even I have one question.
Yes, ma'am.
Do you think forms of leading to punishments, do you think there'll be a misuse of these punishments?
Ma'am, yes, we can say that there will be misuse of punishments because uh, they will not be so deterrent as to put the criminal into so much of fear that they will not repeat these things, these bad activities. Because as compared to other forms of punishment, they are not so serious. If we'll not change the mindset, then nothing can be changed. And also in India there is a different kinds of pressures can be put, even bribes can be given for the non execution of that. So there are challenges in India which will be faced.
Right. Thank you.
Thank you, ma'am.
Thank you so much, participant. So judges, it is we have the next participant, that is presentation number 9 with us. And the next presentation after presentation number 9, that is presentation number 10, that is shifted to the last presentation. And for that, on behalf of presentation number 10, we are taking presentation number 4, which the participant was not present at that time. So kindly mark with that presentation number 10 as presentation number 4. Thank you. So next participant, presentation number 9, participant code 109. Kindly start with your presentation.
Good afternoon, everyone. I am participant number 109. My presentation is number 9. Is my screen available?
Yes, you can share your screen.
Okay, just a second. Just a minute, please. I'll just join from another device. I'm unable to share my screen from this device. Just give me 2 minutes, please. Hello, am I audible?
Yes.
Is my screen visible?
Yes.
Okay. So the topic of my presentation of my research paper is Re-evaluating Access to Justice, a critical analysis of FIR registration under Bharatiya Nagrik Suraksha Sanhita 2023. The Constitution is the supreme law, as we know, and no legislation can undermine its core principles. It not only governs but transforms the society. That is how placing a duty on the state, a constitutional duty to ensure that societal stability and security is maintained. As a constitution evolves, so does the criminal justice system to meet the modern societal needs. The outdated Code of Criminal Procedure 1973 necessitated the enactment of the Bharatiya Nagrik Suraksha Sanhita 2023, which brings reforms, including in the registration of FIR, that is First Information Reports. FIR is the first step in the criminal investigation, and it is crucial to ensuring justice. However, due to inefficiencies and delays in FIR, the access to justice is hindered. The BNSS seeks to address these challenges by modernizing the process, but it raises important questions about balancing efficiency with the protection of constitutional rights. Does the BNSS strike the right balance between the state's need for law enforcement and individuals' rights under Article 21, that is right to life, and Article 14, that is equality before law? So in this paper, I have examined the constitutional implications of the procedural requirements in the FIR process, particularly the impact on access to justice. In this second part of the paper, I have compared the provisions of FIR registration under sections 154, 156, and 157 of the CRPC, along with section 173, 175, and 176 of BNSS, assessing whether the new provisions truly address the inefficiencies of the old system or just create new concerns. The FIR process is vital to safeguarding both the victims and the accused rights. Therefore, it is important to assess the constitutional implications of the same, which has been discussed in the third part of this paper. The newly added zero FIR provision, as was absent in CRPC but recognized by courts, allows FIR to be filed at any police station regardless of its territorial jurisdiction. This reform addresses the issue of delayed responses and jurisdictional conflicts, ensuring quicker law enforcement action. However, it also brings its own risk. While the FIR must be transferred to the correct jurisdiction, the law does not set a clear timeline for this, which could delay the process. Moreover, there's concern about potential misuse, where FIR could be filed in distant areas to harass the accused, potentially violating the Article 21, the right to personal liberty of an individual. The second provision, that is electronic FIR, allows FIRs to be filed electronically, making it easier and less traumatic, especially for the vulnerable groups, to access justice. This modernizes the system and makes the process more accessible, but there are concerns about misuse, as there is difficulty in tracking multiple electronic filings, potential overload on police resources, which could delay investigations and affect the integrity of the justice process. The preliminary inquiry provision, which was not mandatory under CRPC but recognized by court in the landmark judgment of Lalita Kumari versus state of UP, now allows police and BNSS to investigate for up to 14 days before registering an FIR. This provision aims to weed out frivolous complaints but also poses significant risk. It grants the police considerable discretion, which could lead to delays and, more worryingly, discrimination, especially amongst the marginalized communities. This provision violates the right has the potential to violate the right to timely justice under Article 21 and 14, as it introduces unnecessary delays and gives a lot of discretion to the police officers. The magistrate's role under Section 175 of the BNSS, corresponding to Section 156 of the CRPC, has also introduced new barriers on the role of the magistrate and new barriers on the power of the magistrate. The magistrate, now dealing with FIR refusals and private complaints, have to ensure that the person, the aggrieved or the complainant, approaches the superintendent of police first before seeking any judicial intervention. This adds unnecessary bureaucratic delays and burdens the complainant. The magistrate, instead of having direct authority, is now dependent on the police and the superintendent of police, which limits the judicial independence. This process also violates the basic constitutional principles by delaying action and preventing prompt judicial relief. Moreover, requiring the complainant to submit an affidavit and rely on police submissions compromises the right to equality under Article 14, as it allows the same police officers who refuse the FIR to influence the judicial process, leading to bias and arbitrary decisions. Next is use of forensic evidence. The BNSS mandates use of forensic evidence collection and videography of crime scenes while aiming to improve investigation transparency. It also raises constitutional concerns. Poor quality evidence could undermine right to a fair trial, as unreliable or tampered evidence could distort the outcome of the case. In resource-poor areas, lack of proper equipment may lead to incomplete investigations, delaying justice and violating the right to timely justice. In conclusion, while the BNSS aims to modernize and streamline the criminal justice process, it also introduces significant challenges. The balance between societal interests, such as efficient law enforcement and the protection of individual rights, remains precarious. As Justice Krishna Arya rightly has said, procedure is the handmaid of justice and not its mistress. We must ensure that reforms do not delay justice or erode the fundamental rights which are guaranteed by our Constitution. Thank you.
Judges, do you have any questions?
Yes.
Yes, sir. Sir, am I audible?
ऑब्जेक्टिव क्या है इसका FIR का?
Sir,
What is
FIR
the
का
objective?
objective, sir, FIR का objective is to record the facts. It is the first information report about a crime. The objective is to record the facts to provide an accurate account accurate account by an informant of a victim about the crime. It also helps in the investigation process, and it also provides legal accountability. Like, we would know that how a procedure has to start, that if the investigation process that is going on, if it is going on as per or in line with the information that is provided by the witness or by the victim.
सेकंड क्वेश्चन कि जब भी कोई क्राइम होता है,
Yes, sir.
तो क्या FIR को लॉज करना मैंडेटरी है?
Yes, sir.
विदाउट लॉजिंग FIR क्या क्रिमिनल जस्टिस सिस्टम मूव नहीं कर सकता?
So without lodging FIR also the criminal justice system can move. However, in the case of Lalita Kumari, Supreme Court has held that registration of FIR is mandatory, and in other cases also it has been held that registration of FIR is mandatory. So it is because it सर जो evidentiary value है FIR का, that is so that is not hampered. It is important to register the FIR at the beginning only, because अगर वो investigation process start होने के बाद FIR को register किया जाएगा, then it will be hit by section 162 of the CRPC, that it is given to the police officer during investigation and it will not be admissible. So that this does not happen, it is important that the FIR is registered beforehand only, so that बाद में the procedure which takes place that is in line with the information provided by the witness or the victim, and at the end of and at the time of trial, जो ये first information है, that can be corroborated with the subsequent information or the subsequent testimony which is given by the victim or the witness.
Okay, thank you.
Thank you, sir.
I have one question.
Yes, ma'am.
So, is there a judicial standard for reviewing whether the FIR has been properly registered, or what happens if the FIR is being improperly filed or fabricated?
I'm sorry, can you please repeat your question?
Yes. So, is there any judicial standard for reviewing any if the FIR has been improperly registered, or if the FIR has been improperly filed or fabricated? Is there a judicial standard for that?
Okay. Yes, if suppose an FIR is not properly filed or not properly registered, it could lead to investigation delays. It could make the investigation process go haywire. Uh, like there must be some processes, right? There must be some value or some veracity of facts that we are checking, or we are checking through the investigation, right? But if the facts are not only correct, or if the information given is not true, then the whole investigation process will be haywire. It will cause delay in justice. And here the court has the power, like the magistrate has the power under section 156 of the CRPC. The magistrate had the power to even order a correct investigation. Like he had the power in case of refusal of FIR to order the police officer that he should investigate in this matter. If he thinks that there is a potential prima facie case, then he can also, if the investigation is not going effectively, he could also order for a better investigation in the matter. But now, since section 175 of BNSS has come into picture, this also procedure will be hampered, because now we do not know if a person, in this case also where there is refusal of FIR, in that case we know that the powers of magistrate are curtailed a little under 175. But in this case, where the investigation is not going as how it should go, and it is not going effectively, now we do not know if we can approach directly to the magistrate like we could under section 156 of the CRPC. Now we do not know. We will have to see, as per the judicial interpretations of this new provision, that if a person can go to magistrate directly for judicial intervention in case the investigation is not going as how it should go.
Thank you.
Thank you.
So for the next presentation, we have presentation number 4. Participant code 104. Kindly be present with your presentation.
Good afternoon. I'm Shivani Johri. Am I audible?
Yes.
Yeah, I'm just sharing my screen. Is it visible?
Yes.
Yeah, so the topic of my research paper is Concept of Community Service as a Punishment under BNS 2023, a boon or a bane. So, what is community service at first? Community service is a form of punishment that requires offenders to perform unpaid work for the benefit of community as a part of the sentence. So, basically, it's utilizing human resources for the benefit of the community as a whole. And it has been added for the first time under the BNS 2023, which this is a shift from the retributive system, which offers death penalty as a first stance of punishment, to a restorative system and rehabilitative system, towards restorative justice, emphasizing rehabilitation and reintegration of offenders into society rather than purely punitive measures. Now the offenders can avoid traditional punishment by performing community service. So community service seems like a new concept, but it has been lurking in the shadows, especially with the Juvenile Justice Act. A recent example is the Pune Porsche accident, where the judges sentenced the offender to community service. And community Pune Porsche incident, basically what happened, we all know that the it was 2 a.m. and at night, and the Porsche car of a very well-known MLA person, of a very well-known person, just hit a bike. And what happened in this case was that the bail was cancelled by the Juvenile Justice Home, the Juvenile Observation Board, and Juvenile Justice Board, and because of that, the people criticize the juvenile justice laws for the matter. Community service as a punishment also has been widely adopted in Western legal systems. Countries like US, UK, and several European nations have successfully integrated community service into their sentencing frameworks. In US, community service is often used for minor offenses, allowing offenders to contribute positively to society while avoiding the negative impacts of imprisonment. Programs are typically well structured with clear guidelines and monitoring mechanisms to ensure compliance. Similarly, community service orders are a standard sentencing option in UK, often combined with other forms of rehabilitation and such as counseling or vocational training. So we have already seen the acts in US and UK. So we can say what is the, it's not always a form of punishment. If we talk of community sentencing, it is also a part of educational institutions, like in Danish, Spain. We have this as a form of voluntary work, which a person has to complete a high school, then he has to get this voluntary 20 some hours of voluntary work to be done by the people to get a high school degree. So this is what it can be done in lieu of military service or for civil conscription services. It is again a substitution addition to other criminal justice sanctions. When performed for this reason, it may be referred as compensatory service. Again, mandated for schools to meet requirements as a class, as a workfare obligation, as a conditional receipt of social financial benefits like workfare in the UK. So it's not always a form of punishment, but it is obviously a very cost effective and humane source of punishment, which has been used for benefit of the community, as well as a non-custodial form of punishment. Eligibility, if we talk of eligibility for community service is typically reserved for minor offenses, non-violent crimes, first-time offenders, and sometimes we also have the under trial prisoners who are convicted for the for very long time civil offenses, जो civil prisons में है, उन लोगों के लिए भी we have this concept. वैसे तो this is criminally, but we can have this for those offenses. So the guidelines are not totally clear as to what offenses community service can be done. Just because it is utilizing human resources, so we can have it for those crimes also. And this ensures punishment is proportionate to crime, but this is again an ethical concern. Why? Because the ethical concern says that the punishment has no direct nexus with the crime. If we say the punishment is proportionate, I'm talking of the challenges also. The punishment is proportionate to the crime. So in this sense, if we talk that one thing is that it's not directly concerned with the crime. So we have the concern whether the punishment is proportionate. Judges have the discretion here to impose community service based on the nature of offense, the circumstances of the case, and the background of the offender. The court determines the number of hours of community service based on the severity of the sentence. The nature of community service work is decided in a way that it benefits the community and is suitable for the offender's abilities. Examples include cleaning public spaces, working with non-profit organizations, assisting in community development projects.
Participant, you have 1 more minute.
Where is it defined? Quickly, I'll just provisions under BNS. We had 5 type of punishments. This is under 4F of BNS was formally introduced. The 6th form of punishment, that is community service. Now, these are the sections where community service has been imposed in addition to fine as a form of punishment. And we have section 8 of BNS, जहाँ पर if there is no punishment, if person fails to do community service, what punishment will he get? It is ordered. So this is section 202, 209, 226, 303 clause 2. 355. So they are all petty offenses if we see. Then defamation also, 356 clause 2. Public nuisance, false defamation cases, offenders in thefts of property valued under 5,000 can avoid traditional punishments by returning the stolen goods and performing community service. Judgments in which courts directed accused to render community service. These are the judgments. Parvez Jilani, State of Maharashtra, court directed to render community service in BARC Hospital. Manoj Kumar versus Government NCT of Delhi. To community services, Lok Prakash Narayan Hospital every Saturday, Sunday. Babu Singh versus State of UP. Apex Court, restorative devices for means of community service drills, study classes should be innovated upon to redeem the offender. Vishal S. Advani, State of Gujarat. The court ordered the ones who are caught not wearing a mask, the services will be utilized for community services for 10 to 15 days on non-medical services. So especially during COVID times for stricter implementation, this case holds importance. The Gujarat High Court stated community service is not a punishment but a chance for offenders for reparation. Ravi versus State of Haryana. The juvenile was ordered to perform community service for 3 years in the hospital and was supervised by a medical officer. Then we have other again host of cases where Sagar versus State of NCT of Delhi, that is 2023 ka recent case where the Delhi High Court ordered 24 persons accused in an attempt to commit culpable homicide to do basic cleaning work at 4 police stations at Mehrauli, Fatehpur Beri, Maidan Garhi and Nevsarai. The court quashed the FIR after parties claimed to have amicably settled their dispute. So this is also kind of community service cleaning. Again, Goa bench of Bombay High Court ordered 2 engineering students to do community service at old age home for contributing 2 hours on a daily basis. The students were accused of stealing certain items during conference at institute, included potato chips, pens, and chocolates. So say some petty offenses can be done. Planting 100 trees, New Delhi Nature Society versus Shri Dinesh Sheel Saxena. So these offenses. Now, what are the challenges? Basically, if we talk of whether it is analysis of the concept of community service, there are no clear guidelines, there are no monetary mechanisms, and the punishment is proportionate to the crime, we are not sure. Without addressing these challenges, there's a risk of misuse because, again, if we talk of Plato's concept of justice, it talks of morality and righteousness. So, if we talk of morality, it is determined by the community standards. So community may, if the person is actually, it is reducing recidivism, we don't know. So it is actually giving a less punishment than what is being volunteered. Next time he can also steal potato chips, plant 100 saplings and go free. So how can we prevent crime? That is one of the primary challenge. Again, community services is not consistently or uniformly across different cases. So this requires again clear set of guidelines on the type of offenses eligible for community service, the nature and duration of the service, the mechanisms, again evaluating compliance. Again, the ethical concerns have been discussed that involuntary servitude, which particularly assigned tasks do not directly address the harm caused by the crime. Then public awareness and acceptance of community service as a form of punishment are crucial for its successful implementation. It requires a concerted effort to educate the public about the benefits of community service. For that, campaigns and NGO campaigns and awareness programs are fine.
Your time has been over.
Just 1 second. Benefit, we know, again, overcrowding in prisons, NCRB data, prisons are overcrowded. So this is one benefit. It is cost effective and it is promoting rehabilitation, reducing recidivism. Hate for crime again is not the correct thing. Strategies, again, if we just, this is the last strategies, if we talk of that personalization of community service assignments is crucial instead of generic tasks. Assignments should be tailor-made to match the offender's rehabilitation needs and skills, ensuring meaningful and beneficial contributions. So not everyone knows how to do tailoring. So we have to see the offenders' skills and needs of the society, and then we have to devise a certain community service of punishment. Then India currently lacks standards of community service. Guidelines are missing. Again, NGOs and local authorities should come and supervise, and they have to again offer for providing offenders vocational training, counseling, mentoring is important. So these are the strategies we can offer for effective implementation. Basically, it is a new concept which needs to be interpreted not only on Western lines but according to the conditions of the country, and judges have to see it from case to case basis. But the court definitely needs to devise certain guidelines and for the offenders, and what are the offenses for which community service should be provided as a punishment. Thank you.
Any questions from judges' side?
One question from my side.
Yes.
Will there be any misuse of this provision?
Yes, till the time there is no clear-cut guidelines, the law can be used and misused both. Just as I said, that people can, how can it be reducing crime when people can get scot-free just by planting 100 trees? Next time they can also do the same kind of offense, and then they plant 100 trees. And so we have to see how it is actually reducing crime rate. And just by citing logistical problems like overcrowding in prisons, we cannot get away from the concept of punishment. So this
All right.
provision can be misused.
All right. Thank you.
Thank you.
One question. पार्टिसिपेंट, आपने कभी ये सुना है कि कोर्ट क्या करती है कभी कभी कि एक्यूज दो जो होते हैं उनको कोर्ट में कहती है आप बैठे रहिए यहाँ पे 1 घंटे, या कोर्ट के बाहर खड़े रहिए 1 घंटे। क्या ये कम्युनिटी सर्विसेज के अंदर आता है?
No, sir. Community
कवर
service
कवर
means
होगा इसके
any
अंदर?
voluntary work for the betterment of the community. So
बेटरमेंट
community
ऑफ द
community, it means some social
ओके
benefit to the community. If you
ओके
just
ओके
if you just stand outside the court, it is not going to benefit the community as such. If you plant saplings, environment friendly हो गया, या NGO में social education हम दे रहे हैं, या फिर cleaning of the parks and so toilets and all. So if they talk of these things, these can be giving food and langar. In one case, it was offered, like in Pune, Porsche. So these things can be given as a punishment because they benefit the community.
ओके, थैंक यू।
Okay, thank you, sir.
Thank you so much, participant. So for the next presentation, I would like to call presentation number 11. Participant code 111. Kindly be present with your presentation. Presentation number 11.
Good afternoon, judges. My name is Kushagra Singh. My presentation number is 111. Just a second, I'm just presenting. Is my screen visible, ma'am? Hello.
Yes, yes.
So good afternoon, judges. My name is Kushagra Singh, and my title of the research paper is Section 124A to Section 152, Evolution, Controversies, and Implications of India's Sedition Law. So the paper is intended to study the evolution of sedition law in India with a particular focus on the changes from Section 124A of Indian Penal Code IPC to Section 152 of Bharatiya Nyaya Sanhita. While much of the criticism against Section 124A has decried its suppressing dissent and limiting free speech in India, Section 152 turns the state's attention towards act endangering the sovereignty, unity, and integrity of India. However, it omits the explicit term sedition. This omission does not eliminate the potential for misuse, although it retains ambiguous provisions, including phrases such as subversive activities and inclusion of financial means and electronic communication. These elements could broaden state power. As a result, there exists a risk of mislabeling legitimate dissent as a threat, which is serious concern uh, for democratic principles. The BNS introduced a more structured framework and coherent definition with intention of modernizing the legal landscape. The Section 152 imposes significant penalty for inciting succession or armed revolt. However, it permits open criticism of government actions. This is marked shift from expensive prohibitions outlined in Section 124A. Although the term employed in Section 152 are abstract, they raise apprehensions regarding possible misuse and infringement on constitutional right. This paper poses that while the BNS seek to enhance national scrutiny, it complicates the distinction between legitimate dissent and perceived threats, potentially leading to overreach the endangered democratic liberties. The finding emphasize the urgent need for more precise definition and strong judicial safeguard to preserve individual rights in changing legal landscape. Uh, Now to give more introduction to my topic, the in earlier colonial era, Section 124A was introduced in 1870 by Britishers to stop any opposition in their rule. It aimed to punish anyone who spoke or wrote against British government. Legal scholar like those in the book The Indian Penal Code by Ratanlal Dheeraj Lal discuss how this law was used against famous Indian leaders like Bal Gangadhar Tilak, who was tried under sedition for his writings, uh, and Mahatma Gandhi in 1922. These early cases showed that the law was very broad and could punish even peaceful criticism, which many believe was unfair and oppressive. Post-independence development after India gained independence, Section 124A faced criticism for conflicting with rights to free speech under Constitution 19(1)A. Under Constitution Article 19(1)A, in in the case of Tara Singh Gopi Chand versus State 1951, the court struck down the law, calling it unconstitutional. However, the government responded with first constitutional amendment in 1951, which allowed the law like sedition if they were necessary for maintaining public order. The landmark case of Kedarnath Singh versus State of Bihar 1962 became very important in shaping how sedition law should be applied. The Supreme Court agreed that sedition could still be used only for speech that direct led to violence or public unrest. The scholars like S.R. Maineni view this dissent as fair balance, protecting freedom of speech while ensuring states security. However, critics like K.L. Vibhuti argue that even the law was still too broad and prone to misuse. Criticism and misuse of sedition law. In recent years, the sedition law has been widely criticized for its misuse. Many reports and studies, such as those on Manu Patra and SEC Online, shows that the number of sedition cases has increased sharply, with many being filed against journalists, activists, and political opponents. Even though these cases have grown, the conviction rate remains very low, indicating that the law is often used more to silence dissent than protect public order. For example, the arrest of activist Disha Ravi for allegedly supporting farmers' protests highlight concerns about how sedition law is used to control free speech. Legal scholars argues that the law is too vague and chilling effect on and has a
Participant, you have
chilling
2 more minutes.
excuse me, ma'am. Okay.
You have 2 more minutes.
Okay. Has chilling effect on people who want to express dissent. They stress that laws should be clearer and prevent from being used unfairly. Now, transition to Section 152 BNS. The introduction of Section 152, the Bharatiya Nyaya Samhita 2023, replaces the term sedition with act endangering sovereignty, unity, and integrity. Supporters argued that this change make law more relevant to modern threats such as cybercrime and terrorism. However, critics point out the term like subversive activity are still unclear, which means the law should still be misused. The expert have raised the concern that the broader scope of Section 152 in Bharatiya Nyaya Samhita, with punishment like life imprisonment, could repeat the mistake of Section 124A targeting political opponents and activities. But Union government has reasoned that the new provision is no longer criminalizing sedition but criminalizes treason, since criticizing the government is no longer the offense. uh, o- Overall view and conclusion, the opinion in academic literature is that while changes in the Bharatiya Nyaya Samhita 2023 try to address new security challenges, the law still need careful attention to prevent misuse. Many scholars argue that law like sedition must be more specific and strong safeguard to protect freedom of speech, even though the shift to Section 152 in Bharatiya Nyaya Samhita is step forward. How it will be applied and interpreted in court will, will be the key to ensure democratic rights are not compromised. In conclusion, the evolution of sedition law in India shows a long history of balancing the power of state with freedom of individuals. The challenges from Section 124A to Section 152 reflects the attempt to modernize the law, but concern about its potential misuse continues. Moving forward, it will be essential to ensure that law protects both national security and right to freedom of expression. Thank you.
Any questions, judges?
No.
Nothing from me, sir.
Okay. So with this, I would like to extend my sincere thanks to Professor Manveen sir for giving his valuable time for our event. Thank you so much, sir, for judging, and we hope for further meetings with Into Legal World and TS Mishra University. Thank you so
Thank you,
much
ma'am.
for being present.
Thank you.
So for the next presentations, we have Dr. R. Ranjan sir for judging. Welcome, sir.
Thank you. Thank you.
Dr. Radha Ranjan, Assistant Professor, Amity Law School, Amity University, Patna, Bihar. Dr. Ranjan holds a PhD in Law from the Department of Law and Governance, Central University of South Bihar. He has an active editorial member, receiver, and advisory editorial board member of national as well as international journals, respectively, and members of reputed society and organization. Dr. Ranjan has a substantial experience of research, constitutional law, cyber law, artificial intelligence and law, criminal law, and human rights. We welcome you, sir, in this our second day of third national seminar organized by T.S. Mishra University in collaboration with Into Legal World. So for next presentation, I would like to call presentation number 112. Presentation number 12, participant code 112. Presentation number 12. Other participants are here. Okay, I think the participants are not here, so we are skipping this for a while. Now the presentation number 13. Participant code 113.
The screen.
Oh, I'm really sorry, my mic was mute. Again, beginning with good afternoon, everyone. Our code is 113. Am I audible this right now?
Yes, Dipesh, you're audible.
Okay. Good afternoon, everyone. Our code is 113. Our topic is a study of a law of sedition in India, a comparative study between the section 124A of Indian Penal Code and section 152 of Bharatiya Nyaya Sanhita. In this research, we have cover following topics, which are starting by the introduction, historical background of sedition law in India, evolution, post-independence, timeline of sedition law in India, comparative analysis of sedition under IPC, and the offenses principles in the context of the sedition laws, and conclusion. Starting with sedition as a legal doctrine has been a highly debated issue in India, particularly due to its historical roots in the colonial era legislation. The concept was enriched in the section 124A of IPC, which was introduced during British rule, which aim of suppressing any dissent or criticism against the government. Under this provision, acts that could lead to disaffection towards the government were considered criminal offences, thereby restricting individuals' freedom of expression and their ability to critique authority. The law was often misused to target political opponents, journalists, and activities, resulting in the widespread concerns about its potential to the stifle democratic discourse. However, in 2022, the Supreme Court in India made a landmark decision by striking down Section 124A of IPC. The court recognized the provision's potential to infringe upon the fundamental rights guaranteed by the Constitution, particularly the rights to free speech and expression. In the wake of this judgment, the Bharatiya Nyaya Sanhita was introduced, which redefines sedition in the Section 152. According to the data from the National Crime Records Bureau (NCRB), sedition and UAPA cases witnessed a significant increase in 2019, with sedition cases rising by 25% and arrests by 41% compared to the previous year. Despite 93 sedition cases and 96 arrests reported, only 3% resulted in convictions, and with just two individuals convicted and 29 acquitted. The Ministry of Home Affairs confirmed that the trials of the remaining cases are ongoing. Former Supreme Court Judge Justice Deepak Gupta criticized the misuse of the sedition law, advocating for either their abolition or making them non-cognizable, requiring state scrutiny before filing complaints. This paper explores the historical evolution of sedition laws in India, comparing Section 124A of the IPC with current legislation and Section 152 of the BNS. It analyzes the legal and constitutional implications of this provision, highlighting their role in contemporary India. Now, coming on the research methodology, this research employs a qualitative methodology utilizing historical, doctrinal, and comparative methods to critical examine sedition laws in India. The primary sources for this analysis include key legal texts, namely Section 124A of the IPC and Section 152 of the Bharatiya Nyaya Sanhita, alongside important cases, laws, and constitutional provisions, particularly Article 19(1)(a) and 19(2) of Indian Constitution. Secondary sources comprise online articles, blogs, and other relevant legal material. Now, my colleague will continue from here.
If we talk about the historical background of sedition law in India, the concept was first introduced in India by Lord Macaulay, who included it in the draft of Indian Penal Code. However, at the first instance of enforcement of the act, it was not part. In year 1870, an amendment was made and it could be the part of Section 124A. Notable freedom fighters such as Bal Gangadhar Tilak, who was charged with sedition for his writings, and Mahatma Gandhi, who was imprisoned for his calls for independence, became victims of this draconian law. If we talk about the timeline of sedition law in India, in 1838, Lord Macaulay for the criminal laws in India included sedition law. However, in 1860, when the IPC came into enforcement, sedition law could not be the part of it. In 1870, when Sir Stephen made the major amendments in IPC, made it the part of IPC under Section 124A, this amendment was influenced by English Treason Felony Act. In 1891, the first case, Queen Empress versus Jogendra Chandra Bose, 1891, was heard by the Calcutta High Court. In 1948, in the light of independence, laws of British was reread and sedition was suggested to be dropped down from the constitution. In this context, in 1949,
You have 2 more minutes.
in this context, sedition law was removed and Article 19(1)(a) gains the power. In 1958, under the case of Ram Nandan versus State of Uttar Pradesh, High Court declared sedition law to be void. Whereas in 1962, Kedarnath Singh versus State of Bihar made the constitutionality of the sedition law and defined the scope of it. In 1973, under the tenure of Indira Gandhi, the sedition became the cognizable offense. In 2022, S.G. Bomketre versus Union of India, Supreme Court decided to strike down this, but in 2023, BNS included it. This is the definition of sedition under IPC and BNS. There is a major difference between them. The scope in IPC was disaffection without the explicit intent. However, it in the BNS has a focus on the sovereignty. In IPC, it includes the word sedition. However, in BNS, it avoided the word sedition and named it with other similar offenses. It does not include the modern communication method in IPC, but in BNS, electronic and other medias were included. Punishment in IPC was only till 3 years. However, in BNS, life imprisonment and 7 years of extension in imprisonment was given. Sedition and freedom of speech. Sedition was part of Constitution, but after 1949, in Article 19(1)(a), the Constitution guarantees the freedom of speech. In Kedarnath Singh versus State, it clarifies the sedition under Section 124A of IPC. The judgment reinforced that sedition could only be applied when speech posed a clear imminent threat to public order or national security. However, misuse of sedition law persists, often targeting political leaders, journalists, and activists. The debate continues over drawing the line between legitimate criticism and harmful speech. Modern perspective include judicial calls for aligning sedition with democratic values, legislative efforts for reform, and global trends where countries like UK have repealed sedition laws. Philosophical theories like Mill's harm principle and Finberg's offense principle guide the balance between free speech and societal interest. If we connect these harm principle and offense principle with the sedition, it suggests that sedition law intersect with harm principle by criminalizing speech that incite tangible harm, such as violence or public disorder, ensuring societal stability. Conversely, under the offense principle, sedition laws may restrict speech deemed offensive to societal or governmental sensibility, raising concern about misuse to suppress dissent and stifle democratic expression. In conclusion, I would like to say that the evolution of sedition law in India reflects a shift from colonial suppression to safeguarding democratic values, while Section 152 of Bharatiya Nyaya Samhita aligns sedition with public order misuse concern persist. Future reforms must balance national security with free speech, ensuring sedition law protect democracy without stifling dissent. Now I would like to know if you are having any question.
Yes, yes, sure, I have. Can you cite any landmark recent judgment of sedition?
Sir, it is uh, uh, VG Womketer versus Union of India. We are in
Okay,
2000.
except India, have you compared with any other countries about sedition law?
No, sir, it is not
Except
under the
India,
scope of the paper.
but still, for the sake of knowledge, I'm asking.
Sir, I have been preparing it for paper only, and I have not compared it with
Okay,
any
okay,
other country.
okay. One thing more. Any crimes related to virtual world comes under the sedition?
No, sir. Till now, this concept has not been evolved. However, with future cases, Supreme Court may include it under this section.
Uh, uh, what is the concept of virtual world here?
Um, that is online.
Yeah.
So, if you're talking about the online, then electronic medias have been included in the Bharatiya Nyaya Samhita section 152.
Any crimes which is happening in the virtual world comes under the sedition?
Sir, I would like to know what do you mean by the virtual world?
Cyber world, virtual world, cyber crime, all are
Yes.
same, I think.
If we are talking about the cyber crimes, then it is included in 152.
152. With example, can you explain?
Sir, BNS has been introduced in 2023, and till now, any of such cases has not been came forward Supreme Court. In future, when these
Any
type of
relation with
cases will come,
Information Technology Act with sedition? Any relation with Information Technology Act 2000 with sedition? Any relation? Are you finding out?
Sir, suppose if we go by doing something and speaking something which could lead to sedition, then we can be charged for it if we speak anything online and to say that on the virtual world. We could be charged.
That won't come under the cyber terrorism.
Sir, that would come, it could become in both of them.
Last question. What is difference between cyber terrorism and sedition? It's okay, no problem. But thank you. You have done well.
Thank you, sir.
Thank you.
Ma'am, do you have any doubt? Do you have any question?
Yes. Is there like what type of sedition? Like, do you think that it's discouraging people from expressing their dissenting views against the government or anything?
It is क्योंकि पहले जो लॉ था आईपीसी वाला लॉ था वो गवर्नमेंट देयर आर टू टाइप्स ऑफ गवर्नमेंट वन इज पॉलिटिकल गवर्नमेंट एंड वन इज डेमोक्रेटिक गवर्नमेंट तो पॉलिटिकल गवर्नमेंट को इस चीज का खतरा था लेकिन इफ यू टॉक अबाउट द डेमोक्रेटिक गवर्नमेंट तो उनके अगेंस्ट में अगर बोला जाता है तो इट विल नॉट बी कम इट विल कम अंडर द सेडिशन एंड इफ इट इज स्पोकन अगेंस्ट अ पॉलिटिकल गवर्नमेंट इट विल नॉट कम अंडर द सेडिशन लॉ.
All right. Thank you.
Thank you so much, participant. For the next presentation, I would like to call participant code 115.
Ma'am, 114
Oh,
it should be.
sorry. Participant code 114. That's my mistake. Sorry. Presentation number 14, participant code 114.
Okay. Ma'am, am I audible and my screen is visible?
Yes.
Yes.
Okay. So here I start. The title of my paper is an analytical study on the attitudes of higher judiciary on the law of maintenance of wife in India with special reference to the Bharatiya Nagarik Suraksha Samhita 2023. My presentation number is 14 and my participant code is 114. Regarding the introduction and statement of problem, as we know that there are several laws of, regarding to maintenance in India, which is not limited to CRPC, erstwhile CRPC or the BNS. The same the provision, not the same, but the provisions are already provided, were already provided in Hindu Marriage Act, Protection of Women from Domestic Violence Act, Special Marriage Act, and other than it also includes in civil litigations. Now, this results into multiplicity of instituting of maintenance cases by the wives. Now, the content of, if you peruse the content and the spirit of section 144 of the BNSS and the section 125 erstwhile CRPC, it is basically the same. Now, throughout while studying it, I do not find any reason why the same thing was copy and pasted in this in the BNSS. Aside, thereby the thrust of this research, the inquisitiveness was to study the higher judicial attitude, whether they are prone to grant relief to the wives on the sympathetic ground, or or do they apply their judicial mind in interpreting the law. Now, if we consider if they have the read jurisdiction, then there might be a case of overriding their jurisdiction and not mulling into the technicalities, which as a lawyer of a defense lawyer, we generally place those things before your honor. Now, objective of the study. The study, the trend or the higher judiciary attitude towards the maintenance law. And when I mean to higher judiciary, it includes all the high courts and the Supreme Court of India. Now, to assess the judicial attitude to see whether this is made under application of judicial mind or under sympathetic viewpoint towards the wives. The study of law of maintenance with regards to means either the analyze to the study to analyze the different provisions with regards to the maintenance of especially the BNS, CRPC and PWDV Act. Now to framing of hypothesis. Now I have done a research review of literature from primary sources as well as secondary sources. Now I have consulted Constitution of India, the main provisions, the statutory provisions, as well as the case laws. And apart from, I have consulted the electronic media reports and to see the social impact of the issue. And thereby I framed the hypothesis that the objective of section 144 of the BNSS is to provide maintenance to women who are neglected by their husband. The role of higher judiciary has been accommodative to the women in maintenance suits without application of judicial mind. So this is the hypothesis I have framed, and thereby I proceed for the research methodology. Now to process the methodology which I have employed is of two stages. In the first stages, I have studied and segregated all the various statutes where I get the sources of law with regards to the maintenance of wife. Secondly, I have gone through and sampling. Now, because there are plenty of cases, my limitation of this study is from 2024 to January 2025. Regarding sampling, I did my random sampling in selecting 10 number of cases of the higher judiciary and the Supreme Court with regards to only the maintenance laws. Now, these cases were further categorized into two categories, affirmative and negative. When I mean to affirmative, it is all those cases which were passed in favor of the wives, and negative is the vice versa. Now, in favor of the wives and negative also includes those cases where the higher judiciary has reduce the quantum of maintenance. Now, these cases were then further analyzed to determine the factors of the decisions played by pivotal role for the higher judiciary. Now, after analyzing and going and analyzing the data, the findings are that the decree, first of all, the law is very much clear. The judiciary is very much clear that this is an absolute right on the part of the husband to maintain their wife. The decree of constitution is not an exception to disentitle the wife from granting maintenance allowance. Unemployment cannot absolve a husband from providing maintenance. And there is yet to have a consensus between the PWDV Act and the application of guidelines of Rajneesh versus Neha in granting interim relief to the wife. Further,
Participant, you have 2 more minutes.
yes, thank you. Initially, it was assumed that the role of judiciary was playing as an accommodative role towards the wife. But after starting the 10 various case laws, I found that the viewpoint of the judiciary, the determinant factor for the judiciary is to grant social economic justice rather than mulling upon the technicalities of the cases. Now, though, when I am further studying the socio-economic justice concept, I find that this is as another form of judicial activism, which is already under the basic structure of our Indian Constitution. The discussion point of view, they are considering the socio-economic justice and not mulling upon the technicalities. It also means that they are for concentrating on they are not concentrating on the rule of law. And basically, this is the only defense which we can, as a defense lawyer, they can place. Then apart from that, on the one hand, they are not the Supreme Court is not considering the finding of the family court in granting restitution of conjugal rights on the ground that the wife left the home unreasonably. So this also diminished the faith upon the judiciary as a whole. The conclusion, the cases of suicidal attempts by the husband has urged us to revisit the maintenance law and the women protection laws to see whether those are misused or not. Now, Section 144 of the BNSS cannot be the source of income to squeeze money from the husband. The law and higher
Participant, your
judicial.
time's up.
Okay. So am I allowed to only one more minute?
Yes, you can conclude your topic.
Okay. So regarding the interim maintenance part, so in the one side they are the higher judiciary is granting interim maintenance based on the sole point of prima facie disclosure of facts in the petition with regards to commit of domestic violence. On the other hand, they are not giving a chance to the respondent to show to have their written objection. So this is it is very much settled law that when judiciary is about to pass any adverse order against somebody, the natural justice is the prime concern, and this is not this is a natural justice. This is a common law. So other than I also suggest that the divorce law should be revisited with regards to the irrevocable breakdown of marriage should be brought into effect. And others aside, proper procedure should be developed to segregate malified intention of the maintenance case and the actual maintenance case. That's all. You're on panelist. Any questions?
Any questions, judges?
Am I audible?
Yes.
So is there any reforms that you suggest for improving the maintenance laws in India, especially in regards to the changing family dynamics or the economic independence?
Yes, ma'am. I found that the educated and able wife if they are demanding an hefty amount of interim maintenance, from interim maintenance to final maintenance, and the judiciary is also not taking into consideration their ability or the education factor. So education, the law should be particular regarding the educational factor of the woman, the education because they should not be allowed to have the hefty amount, and it is also not good for our country. A educated person is sitting idle and just for the sake of harassing the other party or to squeeze money. This is also not good for a developed state or a welfare state. The country progress shut down.
All right, thank you. Sir, do you have any question?
Yeah. Do you think judiciary is not working very well? That is why you are saying somebody is harassing someone. That is
Sir,
why, yeah.
as of my as of my study, the result, I cannot say that judiciary is not performing. Like what I found, that judiciary has extended its order on the context of socio-political ground or socio-economic ground. So that is already into our system, and this is already a part of the judicial activism. So we cannot blame the judiciary, but the system has to be blamed. The law has to be changed with regards to the
Okay.
particularity of the education factor. Sir.
Okay. It's all about the education factor, not other factor.
Education factor, not only apart aside the neglect and the reasonableness of the wife's leaving her husband company should be adjudged. It should not be based on sympathetic ground. The law should be particular to that respect.
Okay,
Because
you
on
have
one
written
hand,
hypothesis in your paper. Hypothesis. What is hypothesis?
Sir,
And
it is
can you give any type of hypothesis? What are the type of hypothesis?
Sir, null hypothesis and alternative hypothesis. So, regarding for null hypothesis, we can test, and alternative hypothesis there we cannot test. So, it is a pure assumption.
Only two type of hypothesis is there, not other.
No, there are very much various hypotheses are also there. It is also this knowledge is still developing, sir. It's still developing.
Yeah, one last question. Tell me where the researcher, as a researcher, I have all the right not to use hypothesis in my research paper. What type of research I have to follow? What type of research I have to write? Where I have all the right not to write any hypothesis in my paper.
Sir, regarding that, I don't think you have every right to place your research paper as per your liberty. This is the constitutional right. But
is it mandatory?
There is no UGC guidelines as of now that there should be an hypothesis.
As a researcher, I'm asking. As a researcher,
for a better quality, we should have an assumption before proceeding with the research and data analysis.
I'm giving you example. In the empirical research, I am giving you option, not to write. What you will do in the empirical research? I'm talking about.
I will obviously prefer to write. I will obviously prefer writing.
Is it mandatory in the empirical research?
No, it's not mandatory.
In doctrinal legal research?
It's mandatory.
Okay. Thank you.
Thank you so much, participant. For the next presentation, I would like to call presentation number 15, participant code 115. Participant code 115. Okay, I think he's not here, so we are skipping them. Presentation number 16, participant code 116. I request participant code 114 to kindly stop the screen sharing.
Hello, hello. Am I audible, ma'am? Hello, hello.
Yes, you're audible.
Thank you, ma'am. And ma'am, my screen is visible?
Yes.
Yes.
Good afternoon and Jain everyone, respected teachers and my dear colleagues. My team code is 116, presentation number 16, and I'm going to present on the topic criminal law reform, proximity towards police state. India is a democratic country and is a welfare state, but after major amendment in the criminal laws of India, it is always alleged by the opposition that India is shifting towards police state setup from its democratic and welfare setup. Question arises, what is police state according to the Oxford Dictionary? A police state is a totalitarian state controlled by a political police force that secretly supervises citizens' activities. According to B. Chapman in his article Government and Opposition, Volume 3, Number 4, a police state describes a state where its government institutions exercise an extreme level of control over civil society and liberties. There is typically little or no distinction between the law and the exercise of political power by the executive, and the deployment of internal security and police forces play a heightened role in governance. A police force is characteristic of authoritarian, totalitarian, or illiberal regimes. Alternative to an illiberal democratic regime, such governments are typically one-party states, but police state level control may emerge in multi-party systems as well. A police state is often known as a dictatorship or a totalitarian administration. The first instance of a police state can be found in Austria in the 1850s, when a national police force was in charge of maintaining order. The meaning differs based on the values of the person using the word. Some feel a police state exists if the government uses electronic or digital surveillance, while others believe police state requires the loss of more freedoms. Some criminal law provisions that simulate India as a police state are the altered provisions of the arrest under Section 35 of BNSS. Earlier, it was there in Section 41 and 41A of CRPC. Inquiry without registration under Section 173 Clause 3 of BNSS. The period of police custody can be extended beyond 15 days, that is spread up to 40 or 60 days under Section 187 of BNSS. These provisions were previously mentioned in UAPA. And the concept of police commissionerate. Initially, the Uttar Pradesh government has approved the implementation of police commissionerate system in two cities, Lucknow and Noida. Since the past 50 years, there was a demand to enforce the police commissionerate system. In 1878, an initiative to introduce the commissionerate system in Kanpur never materialized. The commissionerate system will give police a free hand to act safely to take decisions regarding maintaining law and order in complex urban milieu. Now, powers of a district magistrate DM under 15 acts lie with the police. Currently, there are 7 commissionerates in UP. Moving on to the historical background. Policing is based on a Police Act of 1861. Under the colonial system, the dual system of police administration was introduced. The overall in charge of the district or region was district collector and superintendent of police, that is SP, and they report to them. The primary objective of this police was, under the British rule, was revenue collection. They needed a force that could support this objective and unleash tyranny and oppression when needed to suit the objective. The worst of the officers from the British police were sent to India, so there was a need to put them under a district collector. The system continued post-independence. The British also brought the police commissionerate system first in Kolkata, followed by Mumbai and Chennai presidencies. The system was introduced even before the Police Act of 1861, the commissionerate system is considered a step towards police reforms. In Prakash Singh versus Union of India, a petition was filed before the Supreme Court in 1996 that raised various instances of abuse of power by the police and alleged that the police personnel performed their duty in politically partisan manner. The Supreme Court issued its judgment in 2006, ordering the center and states to set up authorities to lay down guidelines for
Participant, your 5 minutes are up.
evaluate
Two
police
more minutes.
performance, deciding postings and transfers, and receive complaints of police misconduct. The court also required that minimum tenure of service be guaranteed to police officers to protect them from arbitrary transfers and postings. Police commissionerate system is given under 7th schedule. The police is under state lease. Delhi turned into a commissionerate during 1977 to 1979 in Morarji Desai regime. National Police Commission 6th report released in 1983 recommended the commissionerate system in cities which have a population of 5 lakh and above, as well as places having special conditions. In 2005, draft model police framed by a committee set up by Home Ministry also made a similar recommendation saying metro cities and major urban areas with a population of 10 lakh or more should have commissionerate system. There was a what was the need of the changes? Why there was a lot of changes that has been done, for which we had to make a new law, where we need to make a new act, because there were British, there were at 475 places the British sign was there, which were required to be removed. So first, the 475 places the British sign was removed, and therefore multiple amendments were taken, and that could defeat the object of this act. And so the government decided to do not defeat the object of, because it was defeating the object of the act. So there was required to introduce a new act, which was BNSS, and then another thing, BNS and BSA. New law gave vast power to the police, as we have seen. There is commissionerate system that I was talking about. It is a unified command structure with the commissioner of police, rank of deputy inspector general or above, as it's the sole head of the force within the city. It allows quicker response to the law and order. Power of policing and magistracy is concentrated with the commissioner. These are directly accountable to the state government and the state police chief. They have the lesser accountability to the local administration. While in the dual system, it was absent. The powers was distributed among the two, that is SP and the district magistrate. But in commissionerate system, the commissioner holds the supreme power. We can say that he can use his power as an arbitrary to perform his function. Now I will move on to the conclusion. Every democratic and welfare country should not change its path to police state. There should be principle of check and balance among the institution, and any of the institutions should not use the arbitrary power in the arbitrary manner held in Morarji, M.R. Desai, M.R. Balaji versus State of Mysore. Thank you.
Any questions, judges?
Yes, sure. What are the reforms you expect in the police system? Any personal recommendation?
Yes, sir. Actually, the thing is that, sir, with the new law reforms, we have seen that the law that has been made, the state is turning into a police state, a police rather than a welfare state. So we can say that instead of giving a vast power to the police, we can if the three organs that are executive, judiciary, and legislature, they work with the whole and sole authority of the Indian that has given they have the powers, that if they exercise whole of the powers, then there is no need to give the police the whole power. The police reform, the police the police, there will be no use of this police state. The India will be a welfare state. So this is my answer.
Okay. What is the difference between police and paramilitary police? Is this same? And is this come under the state subject or central subject?
Sir, police come under a state subject. Police is a part of a state subject, and paramilitary is under the military control, sir.
Under which man of the control of which government? Which
Central government, central government, sir. Central government.
okay, thank you.
Thank you, sir.
One question from my side, that is, how can you ensure like a balance between the effective policing and all the liberties which is given by the legislation of India? A balance between both.
Ma'am, if there are three organs, if the check and balance is properly done, then the three organs can well and without interfering between the works of the three organs, the legislature will not interfere in the executive and executive will not interfere in the judiciary, then the check and balance will be maintained. And in this way, this principle the police state cannot be utilized. This is my answer.
All right, thank you.
Thank you, ma'am.
Now presentation number 17, participant code 117. Participant code 117. Okay, he is, I think, not available here. So now I would like to extend my sincere thanks to Dr. R. Ranjan, sir, give his precious time for this seminar. Thank you so much, sir, for being present here and sharing your thoughts and being a part of it. Thank you so much, sir. We will
Thank you.
furthermore for such events and your contribution.
Thank you. Thank you so much. Give it up.
Now I would request all the participants to kindly stay in the meeting. We are having a 5 minutes break until we start with our presentations. So I request everyone to not to leave the meeting. We'll continue from presentation 117. Presentation number 17, participant code 117. Participant code 118, are you ready to present?
Yes.
Okay. So for other presentations, we have Ms. Archana Kumari ma'am, currently working as an assistant professor at Amity University, Patna. She has 4 years of experience in teaching. Her specialization is in corporate laws and also so many papers published as and presented in various national and international conferences. She has done LLM from HNLU Raipur in 2018 and has qualified UGC NET in December 2018. Right now, she is pursuing her PhD in law also. So we welcome you, ma'am, on behalf of TS Mishra University and Into Legal World. Ma'am, I would request you to kindly switch on your camera.
Sure.
Presentation number 18, participant code 118. Kindly start your presentation.
Is the presentation visible?
Yes.
Okay, thank you. A very good afternoon to the esteemed judges. I'm honored to present my paper, which is titled as The Notion of Victimology and Its Implication in the New Criminal Law. I will be dividing my presentation in a threefold manner. So my first set of topics is about crime, emotional reactions of the victims, legal and moral justice. My second set will cover the relationship between the Bharatiya Nyaya Sanhita 2023 and its victim assistance. My third set will be a comparison of victim assistance provided in the UK, US, and in India. So going on to the first set, which relates to the topic of crime. Victim is defined under the section 2X of the BNSS, which is Bharatiya Nagarik Suraksha Sanhita 2023. I would like to read the a definition of victim. It says that a victim is a person who has suffered any loss or injury caused by reason of the act or omission for which accused person has been charged and includes guardian or legal heir of such victim. So basically, my paper has covered only the victims of criminal crime. It does not cover the victims of any natural disaster or anything of that sort. So the important elements in crime basically includes the offender, the offense which has been committed, and the victim. So when we look into the spotlight of the criminal justice system, it mainly covers the crime which has occurred and the offender who has committed that crime. The most disregarded element is the victim here. I would like to substantiate my point on with this regards. So my paper primarily covers the emotional reactions which are faced by the victim after a particular crime scene has taken place. It includes shock, fear, anger, confusion, shame, guilt, grief, etc. Legal justice in our legal society is definitely given utmost significance, no doubt in that. However, it is pertinent to note that legal justice is a subset of moral justice. Moral justice has a wide application when compared to legal justice. So justice here refers to fairness to both the wrongdoers and their victims. So the general notion is that once the perpetrator has been punished, justice is served. But in reality, justice is served only when the victim, to some extent, is able to carry out his or her her life, uh, as he or she was carrying before the particular incident has taken place. So moving on to the second set, I have analyzed that the new criminal law has sound legal principles to give legal assistance to the victims of sexual offenders. For example, Section 65, 70, 174, 200 of the Bharatiya Nyaya Sanhita primarily covers the victim assistance which is given to the victims of sexual offenses. For instance, Section 70 prescribes punishment for gang rape. It says that the fine paid shall be paid to the victim and the same shall be reasonable to meet the expenses of the victim. So again, the punishment for there are other offenses also for which this new criminal law does not prescribe victim assistance exclusively. Moving on to the third set, in the US, there are various organizations which are primarily established for providing assistance to the victims. So they also have a 24/7 helpline number. In the UK, there is a separate legislation which goes like this: Code of Practice for Victims of Crime in England and Wales. This has been enacted. It has around 12 rights, which this code has been enacted exclusively for the victims. So my major recommendation in this concern is establishing a separate organization in India under a separate legislation which exclusively covers the victim assistance. In conclusion, I have deduced that the available resources for victim assistance in India is insufficient when we compare it with the other developed countries such as UK and US. Also, victimology is significant because it cultivates a more compassionate, knowledgeable, and effective approach to crime, which again advocates to right for justice. I'll stop my presentation now. I'm happy to take up any questions.
Your presentation is done, participant?
Sorry?
Your presentation is done?
Yes.
Okay. So, judges, do you have any questions to ask?
Yes. Am I audible?
Yeah, ma'am.
So my question to the presenter is that through your presentation, what are you trying to say about, like, we have the victim compensation scheme under CRPC as well.
Yes.
So how far this BNS 2023 is different from that victim compensation scheme that has already been under CRPC? First one. And the second question I would like to put up here is, if you are talking about victim and their emotional trauma, so this new act, whether it has covered the victim's parents also?
Okay. As I had already covered about the victim assistance which is given in the BNS, regarding BNS is Bharatiya Nagarik Suraksha Sanhita, Section 396, 97, 99, 18 and 176 primarily covers about victim assistance. So I would like to sum up all these sections so that it would give a nutshell view. So new criminal law definitely is providing legal assistance to the victims of sexual offenses only. For example, if we take the offense of dacoity, I don't think there is any specific law or provision which governs the victims of dacoity. Even the victims of such offenses, for example, even marital rape, though it is not an offense, they are still considered as victims, though they do not come under the definition as such. There is no explicit help that is available to victims of such offenses. which is my
No, let's just assume that if you are talking about only the victim includes those offenses which are more of the sexual offenses, right?
yes.
So suppose if the rape has happened and the girl is treated to be the victim as per the new act. So how far this new act will help the victim, as the victim compensation scheme that has already been there in the CRPC. So what are you trying to highlight through your presentation, that how this is different from the earlier law?
Okay. So it is not, there is not much of a difference, but there are few differences, such as if for example there is this provision which says that if the victim of a sexual offense is not feeling comfortable to go to the police station and give her complaint, the police with of course accompanying a lady police may go to her residence or any place of her choice and then take the complaint. So again, that is something which we could look upon. And again, POCSO Act is also covered. So I think
What kind of compensation are you going to discuss in your presentation? Like what kind of compensation, whether it will be just the monetary compensation or anything which will benefit the victim?
okay, monetary compensation is actually given. That's what the provision says. And whatever compensation, whatever fine the offender pays, that will straightly go to the victim, and such fine which is going to the victim shall be it should cover all the medical expenses of the victim. So here in this medical expenses, it also not only covers the physical trauma which he has gone, but also the mental trauma, the psychological, the counseling, and all those are covered. So yeah, it has a wide conundrum.
Okay, fine from my side.
Thank you.
I have one question. What are some challenges which are existing in the implementation of victim compensation schemes in India?
Okay. In my paper, I have primarily covered UK and US, whose population is, of course, we cannot compare the population of India with the population of US and UK. They also have huge resources which helps them to give such assistance. But when we take India, it's not really that easy. And even if we are establishing a separate organization exclusively for providing victim assistance, having only one suppose, for example, in Delhi is not going to help. We're supposed to have in each state, because the population of each state is huge. So that is definitely difficult when it comes to India. Again, we cannot take huge steps, but we can take steps by establishing first in the capital of India, and then subsequently moving to the other parts of India.
All right, that's it from my side.
Thank you so much, participant. Thank you so much, judges. So for the next presentation, I would like to call presentation number 20, participant code 120.
Ma'am, I'm 119, so I think it was 118 that was presenting.
Oh, 119, you can present.
Okay.
I would request one participant code 102 to kindly wait for some minutes.
I hope the screen is visible.
Yes.
Okay. A very good afternoon to respected judges and one and all present over here. My presentation number is 19 and participation code is 119. The title of my paper is Navigating Legal Uncertainty, Examining the Reporting Mechanism in India's Evolving Criminal Procedural Frameworks. Now, I would start by putting across a statement that changes on paper creates the illusion of progress, but without the real world application, it is like having a map without a direction. Impressive, but directionless. Now, why I'm starting across with this statement is because I'm focusing on one of the footsteps of criminal procedural law, that is filing a complaint or registering a complaint, to be precise. Talking about section 154 of CRPC, and vis-a-vis section 173 of BNSS. What key what key difference I find across is in the word of electronic communication. So the major difference in the basics is that electronic communication is being incorporated under the new registration of complaint. Now, when we talk about electronic communication, it has been clarified that by electronic communication, it shall be taken on record by him, in the sense the police officer, on being signed within 3 days by the person giving it. So basically, when we talk about any practical change happening across, then the answer to that is unfortunately no. The reason why electronic communication was in talk or even being recommended by the Law Commission as well was because there was a denial from the police stations which were being very well proved across, even in the Law Commission's report and in various honorable high courts and Supreme Court judgments, that the FIRs are not getting registered. That is how electronic communication as an inclusion method was being suggested for. Now, when we say that the person is able to file a complaint or register his or her complaint using an electronic communication, first of all, making it compulsory to sign it and submit it, this again gives you the hand where it is touching from one year to another year just through a different direction, because you are asking that person to submit it to the police station by this very same mean that it was there previously. So the power of again the police officer remains the same there. Now, further, what is very surprising is when we are talking about electronic communication, BNSS defines electronic communication as Section 2, subsection I, mentioning that it means the communication of any written, verbal, pictorial information or video content transmitted or transferred, whether from one person to another, by means of electronic device, including a telephone, mobile phone, or other wireless telecommunication systems, audio video player or camera, or any other electronic device or electronic form as it may be notified by the central government. Now, this makes a very vague version out across as to how a complaint will be registered or how a person can put across his or her grievances to the police officer and whether it has any practicality out of it or not. So, the first question that I have dealt across is still what extent will the inclusivity of electronic communication extend? Whether we are going to allow a person WhatsApping or SMSing the registration of complaint and then turning into an FIR. It has happened across. Jammu and Kashmir High Court has dealt across such a case where in 2023 it was being said that if a person has informed regarding a complaint through WhatsApp, that complaint can be dealt across as an FIR. So there are such scenarios that has happened across, but then whether there is any footsteps out of it, whether there are any guidelines being put across, the answer to that is no. As of now, it is not there. Then the second part that arises is practical implementation of the system. Whether the pillars of the system, the police officers, or even the judiciary at certain extent, are ready to adopt this version, are ready to have practically incorporated into the new system that is being, in a way, launched across. The answer to that is again, it is uncertain. It is not looking across. The platforms are not ready as such. And that is also being clearly being mentioned. I think someone is having the access and has put across this yellow line, Mr. Rafiq. Limited scope of inclusion for online reporting. So the next part is limited scope of inclusion for online reporting. I hope if the part can be intervened, Mr. Rafiq is using his access and making lines in the PPT if that can be avoided. Limited scope of inclusion for online reporting. It is being mentioned that the e-complaint that can be filed across can be filed across only for a crime which is 3 years, or the punishment is up to 3 years. Now, that making the person practically understand who is filing a complaint, whether that crime that he is reporting is 3 years or not, that is again a question that comes across when it comes to practically filing an online complaint or online reporting the complaint. Then comes lack of openness to adapt the challenges and defense on government allocation of funds. So basically, when we talk about the whole system that is being currently monitored, when it comes to the online part, it is under the CCTNS system, where there is a cloud that is being set up, and that cloud is
Participant, you have 2 more minutes.
yeah, and the cloud is looking across for finalizing the things out. Now, there are several challenges there. The cloud, in a way, itself has the part where whether if someone attacks or there is a cybercrime that has happened, then the whole loss of data can arise. Then comes the lack of acknowledgement and guidance process. So I have compared it with the international uh, laws available with it, international modern techniques being adopted by that. So the main setback here is if I'm putting across any online report to the police, I'm not getting any acknowledgement whether I have my complaint that is being put across to the police, the concerned police station, whether they have received it or not. While at several countries, I will take the example of Hong Kong, within once I submit my online report to them, within 15 minutes I received a successful e-report generated that this was the complaint, this has been received, and this is the person who is looking after the complaint. Then it comes to parts of other countries as well, which includes UK, New Zealand, etc., which again gives receipt within 15 minutes to the informer that their complaint is being registered. Then comes the part of lack of authenticity process. Now, if I want to misuse this process, there can be multiple complaints being filed across. So the main problem that I find is that there is a clear lack of authentication process. The system which prevails in states like Hong Kong, UK, Canada, New Zealand is that there is a verification system linking process that they have put across with a specific time limit for single complaint to be registered, therefore increasing the authenticity and speedy and robust justice system. And the last part is lack of data. There is no data that before BNSS, how much complaints came from online e-reporting or considered by the police or disposed of by the police. Even the NCRB is lacking across for any data providing any information regarding the same. So my conclusion here is legal certainty is the cornerstone of justice, and a job that is being half done is as good as none. So we are very well required to adapt to change, but that change should be solid, otherwise, we're left behind in silence. Thank you.
Thank you so much, participant. Judges, any questions?
Yes. Uh, so my question to you would be, you were talking about the various kind of challenges that the electronic communication is going to face or has been facing. So, and you were also talking about in the conclusion part that it needs to be changed or some kind of suggestions. So, what kind of suggestions will you give in your paper? What type of suggestions will it help?
So, respected judge, as I have put across two main guidelines, lack of acknowledgement and guidance process and lack of authentication process. So there are two things. First, there has to be an acknowledgement whether a complaint is being received. So there has to be an acknowledgement given to the complainant, whosoever is filing the complaint. Second, there has to be a guiding process. So before even filing, and because otherwise there is the law is very clear, if you file a false FIR, false complaint, you can also be prosecuted for it. So now that education needs to be there. How that education can come across? By providing an authenticating process. A person who is filing a complaint first has to give all the check boxes, have to clear out all the part that he has read across, what are the laws that has to be reflected in the system. And once that is being done across, he is fully and wholly liable for filing a complaint. So the part of any misuse of the process will be avoided. And second thing is that an authenticate complaint would have been filed across. So there is a good system that has been that can be created, and we can see across that in the world there are a lot of countries which are already have adopted the system and they are learning it smoothly. So what we can also learn across from them is by adopting different good mechanisms being provided different countries, which in past, in fact, we can very well see in our constitution. We have adopted all the good parts, whatever we thought across at that point of time. So here also, just by mere noting down electronic communication will not work. There has to be steps and guidelines which has to be clearly codified so that there is no misuse out of it.
Okay, thank you.
I have one question. So, are there any effective strategies was used by other countries for regulating the electronic communication? So, if there is some strategies that you want to adapt in India, is there any other strategies?
Absolutely. First of all, respected judges, we need to finalize as to what ways we are going to accept the reporting of information, because that is again not clear. Once we finalize that there is a website where a person can file an online report, uh, because it is a state level thing. Currently, the police is under the state authorities. So then either creating a centralized website or giving guidelines to each and every state police websites, making that website active. We have currently, if we look across, under all the police stations, they are being given email IDs, but there is no data whether that email IDs is active or not, or whether they are being in operation or not. So first of all, that operation system has to come across. They need to be in operation. There has to be check and validity of that as well. Once that is being done, a smooth line process can be put across, where the clear guidelines can be written across by the MHA's office, Ministry of Home Office, mandating certain steps, that these are the steps that you need to follow. First, filing and complaint. Before filing a complaint, that person who is filing has to make across, read out all the provisions that will pop up. Once that is being done, that complainant should be authenticated. We have Aadhaar card now. We have several online systems available, so he needs to be e-authenticated on that basis. And then there should be no requirement of going into the police station for signing that online report, because then you are going back to CRPC. There is no practical change that we are looking across. If we are saying that we have opened up electronic communication, we have opened up online filing of complaint, but that is of no use unless and until you go to the police station and sign it within 3 days. Now, even if we consider that, okay, I am filing it online, whether I am going to the police station and that police officer is taking my FIR is again on the authority of that police station, the police officer. He has the power whether he takes it or not. So the problem remains the same. There is no major change that we are looking across here. So that is where there changes needs to be there, and that can be very well done under the necessary ministries and the offices available. Thank
All
you.
right. Thank you.
Thank you.
Thank you so much, participant. For the next presentation, I would like to call participant code 120 and presentation number 20.
Kindly confirm, is my screen visible and am I audible?
Your screen is not visible to us. You are audible.
Is it now visible?
No. Yes, it is now visible.
Is it visible? Is it visible now?
Yes, it is visible.
Okay, thank you so much. So a very good afternoon to the respected chair and my co-presenters. I am here to present on the journey of sedition law. I'm just going to talk about how the sedition law has evolved. I am the presenter number 120. And to begin with, I would like to state and talk about what Justice N.V. Ramanna has said, that dispute about the sedition law, dispute is it is colonial law, very same law used by the British to silence Mahatma Gandhi. Is the law still needed for a country after 75 years of independence? So this was said by Justice N.V. Ramanna, that what is the need right now for the sedition law. And since we always say that it was adopted by the British so as to silence the raising voice for independence and the disaffection which was created among the Indians regarding the government. So let's first start with understanding what exactly is sedition. So sedition, in a very simplest of term, is an act which has the ability to entice or attempt to entice a kind of disloyalty towards the government. Now you will feel how vague is what I am saying. Now this law is also that vague. I'll tell you how, but let me just tell you briefly how this act came, how this offense came into being. So when Lord Macaulay has drafted this Indian Penal Code, the sedition law was to be made a part of the Indian Penal Code, but he dropped it and it didn't make part of it. It was in 1870s that by the amendment which was adopted by James F. Stephen, that this offense came into being. And when we talk about sedition law in present context, we always talk that it hinges or hampers Article 19(1)(a) of the Indian Constitution.
right? But if you look at the history of this law, you will find that it was in controversy, under scrutiny, and argued upon even in the pre-independence era. The pre-independence era, the judges, the courts were always in doubt to actually get a definition, to actually get into certain kind of boundaries where we can say, yes, this act has been committed in this boundary, so this act is actually a seditious act. Moving forward, I'll have quoted section 124A, and why I say to be vague is just if you could see the bold and the underlined part, which says brings or attempts to brings into hatred. Now, what is hatred? How can you define hatred? There is no, one person can feel hatred for something, another person may not feel be hated by that. What is hatred? What is contempt? What is the disaffection? How will you define these terms? This boundary is not defined, and that what makes this act offense very, very vague. At this point, I would also like to quote the Shreya Singhal versus Union of India case, a very renowned and landmark judgment, wherein the section 66A of the IT Technology Act, Information Technology Act, 2000 was held unconstitutional, and the court has said that terms like grossly offensive, anonymous, inconvenience, danger, enmity, hatred, ill will are very vague and ambiguous, and that is the reason many article writers have been put to scrutiny, and they have suffered because there is a lack of definition, and it has created a loophole for the use by the people, their misuse by the people in against the political dissent which people have. Now, interpretation of section 124A, as I've said, that in the post-independence era, we have a lot of cases where this section has been interpreted, but in the pre-independence era also, we have certain landmark cases like the case of Bangobasi, which was the first reported case of section 124A, where the court has stated that by disaffection means a feeling contrary to affection, and something like dislike, contempt, or hatred. Then we have another landmark case of Nirhendu Dutt Majumdar versus Emperor, where the court observed that sedation can be understood as an act of lawlessness, and when this lawlessness is not there, then a person cannot possibly be convicted for the offense of sedition. And also we have the case of Tara Singh Gopichand versus State, where the court has straightaway held that the sedition is unconstitutional. These all cases are pre-independence era. Now, a very important part which is associated with sedition is the Article 19(1)(a), that is freedom of speech and expression. We always talk that people have freedom of speech and expression. We can express ourselves, we can talk to express ourselves, we can say to things to other people, and we can just share our opinions and thoughts. But often we all forget that there is also Article 19(2), which contains the reasonable restriction. And when we talk about sedition, we talk about the case of Kedarnath versus State of Bihar, wherein this was held. In this case, the court held that yes, there is a problem, there is a kind of restriction which is being created by the sedition law in the freedom of speech and expression, but there is only a restriction and not a ban. So how can you call it unconstitutional? Because it only is restricting the freedom of speech and expression, and this restriction is well within Article 19(2), Article 19 subclause 2, for the benefit of public security, the protecting the unity and sovereignty of the country. And
Participant, you have 1 more minute.
And in general, you just cannot allow anyone to speak anything to whosoever in whatsoever way. So it is in a way necessary. Coming to Bharatiya Nyaya Samhita, section 152 has been adopted. Yes, sedition word is not used, but when you see section 152, it in pith and substance very much there with relevant with section 124A only. The essence of both the sections are same. To conclude, I would like to say that there is a need for the judicial interpretation. Yes, there will be judicial interpretation, and the best way to care and to protect both the right, that is the sedition law, and the freedom of speech and expression, is to create a balance so that neither the freedom of speech and expression is being violated, nor a person is creating a problem of public disorder, or there is creating hamper the unity or the sovereignty of the country. I would like to conclude with the quote of what the Rajasthan High Court has very recently said in the case of Tajinder Pal Singh versus State of Rajasthan, that sedition law is a shield for national integrity, not a sword against the political dissent. Thank you so much for listening to me. Thank you.
Any questions, judges?
Yes. So my question to you is that what is the current trend of Indian judiciary regarding the sedition law 124A? So like on the basis of 124A, whether cases can be registered in today's time?
Ma'am, 124A was a part of our Indian Penal Code. So now, if currently we are talking after the 1st of July, it will be filed under the section 152 of Bharatiya Nyaya Samhita. Even the case which I have quoted has been filed under the section 152. So the judiciary is having this trend of observing more deeply that is there really a sedition, or it is merely a political dissent which has came forward.
Can you cite a recent judgment of the Honorable Indian Supreme Court on the sedition laws?
No, ma'am. I do not remember any very recent judgment.
Okay. Thank you.
Thank you, ma'am.
I have one question.
Yeah.
So, how do you ensure that the law does not disproportionately target the marginalized communities or dissenting their political opinion?
Very, as I have said in a very beginning as well, that this entire sedition law is very vague because of the using of the word. So we cannot define it within the boundaries. So only way to protect marginalized section or to any section or any community of this of our country is to application of a judicial mind to a very deeper level and to understanding it like, yes, there has been a kind of seditious act, this could create a problem, this could disturb the public peace, or it is merely a political dissent and it is nothing more than a vengeful attempt to target a person. So that has to be there. Application of judicial mind.
All right. Thank you.
Thank you, ma'am.
Thank you, participant. So for the next presentation, I would like to call participant code 110, presentation number 110, which was shifted here. Judges, participant code 121 is not available. He will not be presenting his paper. So kindly mark 110 on the place of 110, on the place of 121.
Am I audible and is the screen visible?
Yes.
Okay. I would like to start my presentation now. Imagine this. Instead of being sent to an overcrowded prison, an offender is assigned to clean a local park, or assist in building a school, or even mentor the unprivileged children. Would this be justice served, or would it undermine the seriousness of punishment? This is not just a hypothetical scenario, but it's the reality that BNS, Bharatiya Nyaya Samhita 2023, is trying to create. Good afternoon, esteemed judges and all the fellow paper presenters. My name is Diya Pradeep, and I'm extremely honored and privileged to present my paper on the topic Community Service as a Punitive Measure under BNS 2023, a progressive reform or a flawed mechanism, here before you. My participation code is 110. The concept of justice has evolved over the centuries, from the harsh retributive punishments to the Hammurabi's Code to now what we have come to, the rehabilitation or restoration. Community service that has been introduced in the BNS 2023, it represents a shift that seeks to repair harm while also reintegrating offenders into the society. But as progressive as it may sound, the real question is whether this reform can succeed in India, or will it falter under the weight of societal and systematic challenges. Coming to the first part of my paper, that is the historical and legal context. We all know the theories of punishment. There are four, and the theory of punishment that is in line with the community service is reformative theory of punishment that is grounded in the belief that crime is often a result of external circumstances and societal influences rather than the inherent evil of a person. So the central idea of this theory is that people who commit crimes, they can be guided to change their behavior and reintegrate in the society as law-abiding citizens. So this punishment theory was originated in the time of Enlightenment period, and community service as a punishment, it exemplifies the reformative theory by encouraging offenders to actively contribute into the society, and it creates a sense of accountability and responsibility, as held in the case of Sunita Gandharva versus State of 2020, and I quote, action by the offenders affects the individuals as well as community, and therefore, punishment has evolved from preventive to deterrent to culminate into reparative or reformative theory. The emphasis of community service is not on punishment nor on rehabilitation at times, rather it is on accountability, and I unquote. Coming to other legal related provisions, even in the Code of Criminal Procedure, the community service were regarded as a condition of bail under Section 437, Clause 3, etc. Even in the Juvenile Justice Care and Protection and Care of Children Act of 2015, the incorporation of community service as a post-inquiry measure, it underscores the significance of this approach. When it comes to the discussions on including community service as a form of punishment, we can see that in the 42nd report of the Law Commission of India. Then further, we can see it in the 156th report of the Law Commission of India. And additionally, we can see it in the Justice Mariment Committee report of 2022, where they have advocated for community service as a method of punishment. Even in the case of State of Punjab versus Dhananjay Singh, 2018, it underscored the importance of reformative principles and favored that correction is rather important rather than punishment when suitable. Coming to the recent legal developments, the explanation of community service has been provided under Section 23 of the Bharatiya Nagrik Suraksha Sanhita, and Section 4F of the BNS, Bharatiya Nyaya Sanhita, has established that community service as a punitive option for specific offences, which includes a range of offences such as unlawful trade by public servants, indecent public misconduct by the intoxicated individuals, defamation, attempt to commit suicide, etc. One of the most important part of my paper is the comparative analysis with respect to global practices. So United Kingdom in comparisons offers a more flexible approach where they tailor where they allow sentences tailored to the offenses and the offender's needs. So these sentences, they combine unpaid work, rehabilitation programs, etc., and they create a balanced approach. Norway is another example where the model, it integrates community services as well as social services. So offenders, they also gain access to therapy, education, vocational training, etc., and this has helped in reducing recidivism. Another example is Australia, where diversion programs are offered to young and first-time offenders. And also there has been a comparative study of Belgium, Netherlands, Scotland, and Spain, where one of the key findings was that demographic factors also influence sentencing. For example, in Spain, employed and educated offenders were often received community service, whereas the people who were from deprived backgrounds or marginalized groups, they were more often underrepresented, which brings me to the next part of the paper, which is benefits of community service.
Participant, you have to present.
Sorry?
Have 2 more minutes.
Thank you. There are 4 benefits. First is that as of 2021, prisons in India are operating at an occupancy rate of 120%, with many facilities exceeding their capacity. This was confirmed by the National Crime Records Bureau, Prison Statistics of India in 2021. And secondly, over 70% of the prisoners belong to economically weaker sections of the society, as confirmed by the Justice Verma Committee report in 2013. So giving them an alternative to imprisonment is more in line with giving them a chance of better survival. Thirdly, cost of maintaining a prisoner in one state is between 2,000 to 3,000 per month, and by implementing community service, we can use these resources and these costs and redirect it towards development initiatives or rehabilitation. This was confirmed by the National Institute of Criminology and Forensic Science. And lastly, the focus on rehabilitation, it also contributes to reduced recidivism rates. In India, there is no particular study which confirms this, as the implementation is still at par, but there was a study published in the National Institute of Health where the authors, they analyzed data from over 19 countries, and the results proved that recidivism rates in individuals receiving community sentences were lower. And the next part of my paper is drawbacks and challenges. There are mainly four drawbacks that I like to focus on. First is that community service is often perceived as a lenient form of justice. And in a country like India, where dominance is given to the retributive justice system, this skepticism can undermine the public's trust in the justice system, especially in cases where the public anticipates a harsher penalty. Secondly, lack of legal and administrative frameworks. This is where it is common knowledge that currently India lacks a detailed infrastructure to ensure the consistent application of the community service sentences. And thirdly, effective monitoring of the community service sentences. It also requires a very well-developed administrative infrastructure, which is lacking in especially rural areas. And lastly, without clear guidelines on proportionality, there is a risk that overly harsh or excessive community service orders can be given to certain individuals, and this can erode the public trust in the justice system, which was confirmed by the 273rd report of the Law Commission of India. Now, concluding, there are also 3 recommendations I would like to propose. First is that in order for this community service to function effectively, the guidelines must be defined. The guidelines must define the task, the suitable task, the enforcement mechanisms, as well as the eligible offenses. Secondly, the effective monitoring mechanisms are essential to track these offenders and ensure compliance with the orders. And thirdly, these initiatives must account for the India's socio-economic diversity, and it should ensure equitable access to marginalized resources and groups as well, and tailor sentences that are in par with their needs. So to conclude that, I'll say that while the introduction of this community service as a punitive measure, it represents a progressive shift towards rehabilitating offenders, it's also critical to analyze its efficacy, and it's a double-edged sword, because on one hand there is this reform that offers an opportunity for offenders to reintegrate into society, and on the other hand there are many concerns over its practical implementation. So while this reform holds a promise, it's important that its success is dependent on addressing the challenges and how to overcome these challenges, so that the community service is not just a mere substitute to incarceration, nor it is just an attempt to downplay the gravity of offenses. I'd like to conclude with a quote: rehabilitation comes not by incarceration, but by integration into the fabric of society. Thank you.
Thank you so much, participants. Judges, any questions?
No, nothing from my side.
Okay. Shweta ma'am?
Yes, actually, I want to know that how can the courts ensure the community service imposed is not exploitative in nature?
Ma'am, the thing is, right now there are no clear guidelines as to, even though BNS Section 4F in particular, it lays down the kind of offenses for which community service can be granted. There are no guidelines as to the extent of it, like what kind of community service can be granted, what are the targeted individuals or the specific age groups, or how long the community service should be granted. So all these guidelines, I believe the court has the power to the court, through judicial interpretation, it has the power to make rules and enforce rules, laying down the guidelines for which community service can be, applied in the further instance. So I believe court has the power to, obviously, since the PNS has only been introduced in 2023 December, and the implementation is still ongoing, and there has not been many cases where in India particularly where we can see that community service has been granted, because I did a thorough research, and in 2024 I could only find few cases, the Supreme Court cases, where community service has been granted. So I believe it is a job of the court to analyze, in particularly in cases involving all the offenses provided under the PNS, to analyze what kind of the guidelines and the particular, what do you say, particular, uh, I'm not getting the word right now, but mainly to provide those guidelines as to for which offenses this, not offenses, to which category or the kind of tasks that can be given. I think it's the job of the court to put down these references.
Thank you.
Thank
That's it
you.
from my side.
Thank you so much, participant. For the next presentation, I would like to call participant number 121 with presentation number 21. Participant number 122, kindly present your paper. I think is not available right now, but he is there in the meeting. So for now, we are skipping him. So for the next presentation, I would like to call participant code 123 123 with presentation number 23. Participant code 123 is presenting within a minute. Are the next participants are present in the meeting? Presentation number 24. Presentation number 25. Presentation number 26. Presentation number 27. Presentation number 28. Presentation number 29. Presentation number 30. This is presentation number 23.
Yes, good evening, judges. I am participant number 123. Today, I am going to present my views on dowry, that's which comes under section 80 of BNS. So now I am going to start from introduction. Dowry related violence and deaths are a persistent problem in India. Despite legislative efforts to curb the practice, the paper aims to critically review the Indian legal system's responses to the dowry deaths. Historical background. The dowry system in India has its roots in ancient times, initially serving as a financial support for the bride. Over time, the practice evolved into a social norm often associated with the economic and social status of the bride's family. Legal framework. The Dowry Prohibition Act 1961 prohibits the giving and taking of dowry, but has been criticized for its weak implementation. The Indian Penal Code (IPC) sections 304B and 498A provide for punishment for dowry-related crimes. The Protections of Women from Domestic Violence Act 2005 provides protection to women from domestic violence, including dowry-related violence. Challenges in implementation: underreporting of dowry deaths due to societal pressure and stigma, slow legal process and lack of effective investigation prosecutions, social and cultural norms that perpetuate the dowry system, lack of awareness among women and their families about their rights under the law. Case studies and statistical analysis: despite legislative efforts, dowry deaths continue to occur with thousands of cases reported annually. The problem is more prevalent in rural areas and among lower socioeconomic groups. Recommendations for reform: strengthening law enforcement and ensuring effective investigation and prosecution, introducing fast-track courts for dowry death cases, public awareness campaigns to educate women and their families about their rights under the law, providing support systems for victims including legal aid, counseling and shelter homes. Conclusion: the Indian legal system has made efforts to address dowry deaths, but more needs to be done to strengthen the law and its implementations. A multifaceted approach is required, including legal, social, and educational reforms to combat dowry related violence effectively. Thank you so much, Jairus. Now you would like to ask any questions?
Firstly, I would like to know your code.
123.
Okay. So now you were talking about dowry death.
Yes, ma'am.
So what is the recent judgment of Supreme Court that talks about the false filing of dowry death cases in India in the last 2 years?
Ma'am, I don't know about it. Sorry.
So you have proposed in your presentation that the law needs to be changed, or lot of things need to be done while dealing with these dowry death cases. Sorry, right? So don't you think, have you attached or have you read the data of NCRB 2022? The National Crime Records Bureau in the year 2022 has released a data that
No,
talks
ma'am.
about more than 75% of the cases in India related to dowry death are fake. So
No, ma'am.
how
Sorry.
so how would you going to deal with such kind of problems? While dealing with the actual dowry death cases, there are still the cases that has been filed that are actually false. So how would you maintain that balance in the law?
Ma'am, I already had explained it. And I don't know about it. Sorry.
Okay.
Thank you, ma'am.
Thank you so much, participant. Thank you, judges. For the next presentation, I would like to call presentation number 24, presentation number 25. Are they present here? So kindly raise your hand if you are present here. Presentation number 26. Presentation number 27. Presentation number 28. Presentation number 29. Presentation number 30. Judges will wait for more 5 minutes, otherwise we will conclude our seminar here only. And those who are not present here will mark as absent. No marking will be given.
The participants must have been informed about their timings, no?
Ma'am, the schedule was priorly shared yesterday night and in the morning also, and we are continuously calling them. So now
Okay,
it's
fine. Then
the
on this, they are disqualified.
yes, ma'am. So, ma'am, we will wait more for more 2 minutes because the participant number 130 has assured us that he will be joining us within 2 minutes. So let's wait for him, otherwise we will be concluding.
Sure. Oh,
Yes. So judges, I think Prabhat Avasthi is here as our participant number one, participant code 123, 130 to present his paper. Prabhat, please start your presentation. Participant, are you ready to present?
Hello. Presentation number 130.
Yes.
Presentation number 130.
Can you please speak a bit louder?
Presentation number 130. Hello.
Yes,
Am I audible?
you're audible to us.
Can I present my presentation?
Yes, you can start.
So, Mr. Prabhat, are you going to present or we should just conclude?
Participant 130, kindly start.
There is my presentation. There's a and right
Participant, are you going to present or you need time? Participant number 124 with presentation number 24 is also about to join. He is joining. He was dealing with some technical issues. So he will be also presenting after him.
Okay. Hello, good evening, ma'am. Hello, am I audible?
Yes, yes, now you're audible.
My presentation topic is human rights.
Participant, can you please switch to a network area? Your voice is clashing.
Okay, okay, ma'am. I will try, ma'am.
Yes, yes.
I will try, ma'am. There is a network issue.
Right now, your voice is good. You can start with the presentation without taking further time.
Okay. My presentation topic is right to my presentation topic is human rights and right to education. The Right to Education Act RTE in India provided free and compulsory education to children between the age of 6 and 14. The RTE Act was passed in 2009 and come into force into 2010. Gov- Government school cannot deny admission to a child at any time during the academic year. School management committees, SMCs, the
I think is out of network. I think is out of network area. So we will be marking him on. Oh, he's again back.
am I audible?
Yes, yes. Without sharing screen, you can also present. We have your paper with us. We'll mark.
Okay. Thank you, ma'am. Ma'am, my presentation topic is uh, human rights. Right to education. The Right to Education Act RTE in India provides free and compulsory education to children between the age of 6 and 14. The RTE Act was passed in 2009 and came into force in 2010. Government school cannot deny admission to a child at any time during the academic year. School management committees, SMCs, the Act was passed to ensure that every child in India receives proper education regardless of their family income, caste, gender, or creed. Ma'am, may I audible?
Yes.
Right to equality. The right to equality in law in fundamental rights in India that is granted by Article 14 and of the Constitution of India. The article says that everyone should be equally in eyes of the law. It is implies that no one should have any special privileges based on birth, creed, on other factors. The part of the articles state that everyone should be treated equally. Article 17 guarantees equality of opportunity in public employment. Article 17 abolishes the particle of practice of untouchability. The government shall not deny the protection of the laws. The laws apply in the same manner of or regardless or of a person protection of the laws regardless of a person status. Discussion. The Universal Declaration of Human Rights UDHR states that all human beings are born free and equal in dignity and rights. It also states that all people are endowed with reason and conscience and should act towards on one another in a spirit of brotherhood. Observation. Monitoring, it is a like keeping a watchful eye on the pulse of human rights. By monitoring, we aim to improve the protection of this right, whether it's through independent human rights organization HROs or international bodies. Monitoring helps reinforce the state's responsibilities, the respect, protect, and fulfill human rights. It's like shining a spotlight on both the good practices and the gaps. Thank you, ma'am. My presentation is over.
Any questions, judges?
Just a query to you that how this topic, right to education, is coming within the domain of the criminal laws.
Ma'am, human rights is a fundamental right of every citizens of India, and there is a protection of humans.
Okay, we can proceed further.
Okay. Okay, ma'am. Thank you, ma'am.
For the next presentation, ma'am, the participant was joining. Let me just confirm whether he is joining us or not. Then we will conclude.
What was this code? His code? Sorry.
130.
130. Hello.
Yes, ma'am.
What was the code of that right to education presentation?
130, ma'am. Presentation number 30 and the participant code was 130.
Okay, thank you.
Can I improve?
Yes, you can. So, ma'am, the participant is not able to join us due to some technical issues. So, with this, we are concluding our event. Thank you so much, everyone, for joining and being a part of third national seminar on new criminal laws by T.S. Mishra University in collaboration with Into Legal World. I would like to extend my sincere thanks to Ms. Archana ma'am also for being judge to this event and giving his valuable time to us. Thank you so much, ma'am, for sharing your views also.
Thank you. And it was a pleasure judging the event. Thank you.
Same here, ma'am. Thank you so much. And we will look more further to connect with you further events of Into Legal World.
For sure. Sure.
Thank you so much, ma'am.
Okay. Thank you, and my best wishes to you and the team as well.
Thank you so much, ma'am. Thank you, all the participants, for being patient and for being present here. Thank you to our esteemed judge, Ms. Shweta, for being present here all the time from morning. Thank you so
My
much.
pleasure.
The result will be declared soon. We will be informing you through your mail or through the WhatsApp group. Thank you, everyone, for joining.
Thank you.